So Marla, if you could take us through that.
Okay, Commissioner Bittner,
Here.
Commissioner Conley,
Here.
Commissioner Jarrett,
Here.
Commissioner Munson,
Here.
Commissioner Patrick,
Here.
Commissioner Rich,
Here.
Commissioner Small,
Here.
Commissioner Streifel, and Chairman.
Here.
All present.
Fantastic. We have a quorum. We will move into the approval of the February meeting minutes. Any changes needed?
Move to approve. Second.
Okay, it has been moved and seconded to approve the February meeting minutes. All in favor, say aye.
Aye.
Any opposition? Hearing none, minutes are approved. We'll move into the public comment portion of the meeting, and to lead this off, I just want to say this is for, public comment is for Burleigh County residents and landowners. We will have public hearings later, so this is, we will definitely, if you're here to talk in a public hearing, you don't need necessarily to talk at the public comments, but you sure can if you'd like. To start this off, we do have some legislators in the crowd. Thank you for coming. If Commissioner Conley, if you could introduce the legislators and maybe invite them up to say their piece.
Well, they're actually not going to speak tonight because it's an ongoing conversation, but I'll let everybody know the reasoning. This ETA conversation is a follow-through on a promise that actually for me has originated since 2015. Commissioner Bittner and I have talked about it in the past, even before I was an elected official, bringing this conversation forward because there was a lot of people in the county that wanted it to happen. And kudos for the city of Bismarck and Burleigh County Commission, all 10 of us getting in the room. And this is not an easy topic to overcome. There's a lot of moving parts to it, but we've moved the needle in the most significant way since 1977 to move things from regulation without representation to now, as of last week, regulation with representation for 95% of the county residents that were formerly in the ETA. But a couple of our commenters at both Planning and Zoning, City Commission and County Commission, were talking about what about the 5%? And that takes a legislative effort to have a discussion to see if we can look at that differently and answer it for both people that are still in the ETA and out. And so I've had primary discussions with Mike Berg from District 8 and Dick Dever, Senator Dick Dever. He's actually on the committee that oversees the ETA. And we're talking about a bill to where we could possibly redraw the lines to where the state can wash their hands of where the city would say, well, it takes legislative or we're just following state law, but we're still in the struggle of regulation without representation. If they handed that toolbox to us to where we could draw those lines and give that control to a commission, Fargo can be Fargo, Bismarck can be Bismarck, then we can make the decision locally and address those other people that are still left in the ETA. It's evolving, it's ongoing, there's some things to overcome, but I appreciate them stopping by even though it's for a short amount. The other representatives is Senator Diane Larson from District 30 and House Representative Mike Motzenbrucker from 47. But I've talked to other ones like Senator Dwyer from 47. I've talked to a couple of the people that are running that have a pretty good chance of being there. So for the 2027 legislative session, this could be one of those things to where we can actually address every citizen without leaving anybody out. And just wanted to let everybody know. And we'll be carrying them on. I'll be addressing the City Commission the same.
Okay, thank you, Commissioner Conley. Yes, Commissioner
I'd
Rich.
just like to comment, this is a zoning commission. I don't know if this is a proper forum for that. But regulation or oversight without, would you say it? Regulation without representation? Mm-hmm. Okay. Well, I have property in Morton County and Mandan, and I get all kinds of regulations, and I pay all kinds of things. I got a special assessment of far beyond $100,000 coming up, and I don't get the vote in Mandan or Morton County. That's just the way it is. The people in the ATA, they pay school district taxes, so they get to vote on the school board. They don't pay city taxes, city property taxes, and that's the rationale behind that. So it is what it is. But we took care of 95% of these people. That's
Right.
pretty good.
Yeah. At the same time, we live in a representative republic to where these discussions can always be ongoing, and it's codified in our national constitution. We can grow towards a more perfect union.
Yep.
And there's an opportunity to do that. That's why we have committees and boards, including planning and zoning.
All right, I don't want to get sidetracked on this. I guess thank you for the introduction. Thank you for your attendance. And is there any further public comment?
Thank you for the opportunity. My name's Diane Larson. My name's Diane
Perfect.
Larson. I live on Fox Island. Just for your information, you may not realize that when you are living in the ETA, and then the city is the one that determines what you have to do as far as getting any permits or any building code types of things, even though you don't live in the city. So, for example, back a long time ago, when we built our home, we wanted to build our house at a higher elevation. We were told no, because then we'd have enough room for a basement, and basements flood. And we said, okay, we'll fill it in, but we want to build it at a higher elevation. We were not allowed to get our building permit at all if we built it higher, so we didn't. And in the 2011 flood, we had water in our floor joists and for 3 months. And so we did have damage because of that. And so we didn't get to have any say as to what was going to happen or who should say what kind of building permits should be allowed or not. We were just under that authority without representation. So I really appreciate this discussion happening. Thank you.
Thank you, Senator Larson. Yes, Commissioner Rich.
Senator Larson, what if the people in the ATA would start paying city property taxes? Then they would get the representation. Would you be receptive to that?
But if they paid, if the people in the ETA paid city property taxes, then they should also get all of the services, like fire, yeah, but also even the plumbing. We just had to put in a new septic system. And that was what we paid for. Okay. And so the kinds of things that are what you get to have living in the city are wonderful things. But if you live in the county and you choose to take care of your own stuff, you should be able to have a little bit more autonomy.
I just say that the plumbing and thing is paid for through the utility fees, or when you develop it, you pay that, but you get police and fire protection where you live now from the city of Bismarck.
No.
Oh, you get,
No.
our police extend out. I tell you what, if your house is on fire, our fire department will be there to help.
Well, Commissioner, we have the sheriff's department that would take care of this, us in the county, not. The city police don't come out to our house. I would imagine if there was a huge disaster or something that was imminent, they would come into that ETA to assist, but they wouldn't be the primary person once the sheriff came.
Yeah.
So-
Just 2 weeks ago, we sent our SWAT team north of Mandan to help in an incident.
Sure,
Yeah.
because different jurisdictions do help each other at times of an emergency, but
Yeah, absolutely. Thank you.
Memorandum of understanding,
It
joint
is.
powers agreements, and those sort of things are common.
yes,
Yeah,
thank you,
I
Commissioner.
appreciate the comments. I know a lot of this
Thank
is
you.
probably going to be reserved for the session.
I
Definitely.
just
I'm sure
wanted
this
to
will
say
come
thank
up.
you
Yeah.
for taking on this discussion.
Thank you.
You know, Mr. Chairman.
Yes,
before we
Commissioner
go
Bittner. Yeah.
Further, don't we do the Pledge of Allegiance here at these meetings?
We haven't in the past, but
The legislature did something about that.
oh,
All
we can
meetings-
definitely have that added to the future
Let's
agendas. Absolutely.
Do that for the next, I think
Yeah,
that's.
if we could add that to the future agendas, the Pledge of Allegiance. Thank you. Any further public comment?
So is there going to be opportunity to speak on item 6 later, or?
Yes,
Oh, okay.
correct. Thank you. Any further general public comment? If not, we'll move into the consent agenda. Is there any reason anyone would like to open any one of the 2 items under the consent agenda? If not, we can approve the consent agenda to move those 2 hearings.
I'll move we approve the consent agenda.
Second.
Okay, it has been moved and seconded to move the consent agenda, or approve the consent agenda to move to public hearings. All in favor, say aye.
Aye.
Any opposition? Hearing none, the consent agenda will move forward. We'll move into our public hearings for the evening. We have 6 public hearings. Our first public hearing is for the All-American subdivision. And so if Marla or Mitch, if you could come up, give us a few details, and then we will open the public hearing for comment.
Okay. This is the All-American subdivision. Its petitioner developer is Nathan Jensen. Toman Engineering is the engineers. It's located in part of the northwest 1/4 of Section 9, Township 139, Range 79 West, and the address is 8203 Apple Creek Road. And it's 1 lot containing 5 acres, more or less. The zoning is agricultural, and Apple Creek Township has zoning on this. The petitioner is requesting approval of the final plat and a due pass recommendation to the Board of County Commissioners. The announcement was posted in the Bismarck Tribune February 25th and March 4th. Surrounding property owners were notified February 27th, and it was put on the Burley County website February 27th. And Burley County was approached about constructing a shop building on 5 acres on a lot parcel that contains 21 acres. Because the lot is less than 40 acres, the petitioner was advised to plat the parcel into a subdivision. Toman Engineering met with county staff regarding the preliminary plat. Staff had concerns regarding the floodplain and adjoining floodway on the west side of the property. Burley County Planning and Zoning Commission approved the preliminary plat on February 11th. Staff findings. This subdivision fulfills the requirements of Article 33 of the Burley County zoning ordinances. The final plat has been submitted to all reviewing entities, and all concerns and corrections are addressed. The zoning is agricultural. Apple Creek Township has approved this subdivision, and this subdivision meets the requirements of the Burley County Comprehensive Plan, Article 3, Residential Neighborhoods, Objective 1 and 2. A stormwater management waiver was approved on February 16th, and a paving waiver was not required. Staff recommends approval of the final plat and giving a due pass recommendation to the Board of County Commissioners. And you can approve it and give it a due pass, or approve with conditions, deny the final plat, or table the final plat for more information.
All right, any questions for Marla before she steps away? Okay, seeing none, thank you, Marla. We will open the public hearing on the All-American subdivision. So if anyone would like to speak in this public hearing, please approach the lectern, introduce yourself, tell us where you're from, and sign in.
My name is Nathan Jensen. I concur with what was just all said, and I'm the owner of the property. If you guys have any questions for me.
Any questions for Nathan? Seeing none.
Appreciate it.
Appreciate you coming.
Thank you.
Is there any further comment in this hearing on the All-American subdivision? And last call, if anyone would like to speak on this All-American subdivision, please approach. Seeing none, we will close the public hearing and move into comment and action. Anyone have any discussion or action they would like to take on the All-American subdivision?
Well, I'll move we approve as presented and send it to the Burley County Commission for final decision.
Second.
All right, it's been moved for approval by Commissioner Rich, seconded by Commissioner Streifel. Is there any discussion? Seeing none, we'll move into a roll call vote. Marla, if you could take us through that?
Okay. Commissioner Bittner,
Yes.
Commissioner Streifel,
Yes.
Commissioner Conley,
Yes.
Commissioner Small,
Yes.
Commissioner Jarrett,
Yes.
Commissioner Rich,
Yes.
Commissioner Munson,
Yes.
Commissioner Patrick,
Yes.
and Chairman.
Yes.
All approved.
Okay, All-American subdivision, that will move to the County Commission with a do pass recommendation. Moving to our second public hearing of the evening, that is Apple Creek Ridge Second Subdivision. And looks like Marla is going to be coming up here, give us a few details of this before we open the public hearing.
You're going to see me a lot tonight.
We appreciate it.
This is Apple Creek Ridge Second Subdivision. The petitioners are Russell and Jennifer Heaton, and the engineering is Mark Isaacs, Independent Land Surveying. It's a lot combination, Block 7 and 8 of Block 3, Section 35, Township 139, Range 79 West. And the address is 11517 Creek Top Road. It will be a one-lot subdivision containing 3 acres, more or less. The zoning is rural single-family residential, and they are requesting approve the plat and give a due pass recommendation. The Bismarck Tribune posted it on February 25th and March 4th. Surrounding property owners, February 27th, and the Burley County website, February 27th. And Burley County was contacted with regards to a proposed lot combination for 2 lots located in Apple Creek Ridge subdivision. The owners were advised to do a short plat subdivision. This subdivision fulfills the requirements of Article 33 of the Burley County zoning ordinances. The final plat has been submitted to all reviewing entities. All concerns and corrections are addressed. Zoning is R1, rural single-family residential, and this subdivision meets the requirements of the Burley County Comprehensive Plan, Article 3, Residential Neighborhoods Objective 1 and 2. A stormwater management waiver was not required, and a paving waiver was not required. The petition for the final plat meets all the administrative requirements of the Burley County zoning ordinances. Staff recommends a due pass recommendation.
Okay, any questions for Marla? Seeing none, we will open the public hearing on the Apple Creek Ridge Second Subdivision. So if anyone would like to speak in this public hearing, please approach the lectern. Tell us who you are, where you're from, and sign in.
I have a question. Have the lots in this subdivision already been sold?
Oh, can we start with your name?
Oh, sorry. My name is Corridon Hughes. So in this Apple Creek Ridge second subdivision, have other, as part of the original subdivision, have lots been sold or occupied?
Okay, I don't know, Marla or Mitch, can you answer that?
No, they haven't been pulled out of that subdivision, and this is just combining 2 lots within the subdivision.
Okay.
In the original subdivision that these lots are part of, are there lots sold?
Are these lots sold?
Not these lots, but are there lots sold that are part of the original plat?
Yes,
Okay.
there are 2 separate lots.
Have the other owners that are part of the subdivision been asked to sign approval of this?
No, they were notified of the public hearing.
Okay. So I only ask because I have a similar replat petition before that's stuck at the county commission, where I'm asking for a similar thing to combine multiple lots into one. That was contended by the original developers. And it was sent to state's attorney for opinion, who quoted chapter 40 on the vacation of plat before or after sale of lots. So if you're vacating a plat or any part of a plat and where lots have been sold, that you have to get the signatures of approval from every owner that's part of that original plat before, and she considered that requirement before replatting. And so I ask, is this different?
Is the one that you're speaking of, is that the one where it's taking one piece out of this, or combining?
Well, it's combining 3 lots, 2 of which are not part of the subdivision. And-
Okay, so it's outside and inside the subdivision type thing. Okay. I don't know if that changes anything, Marla?
We haven't heard from the state's attorney. We had requested it in writing. But this is a little different than his. These are 2 lots that are in the subdivision. So they are right next to each other. With the Hughes subdivision, it's 2 lots that are outside the subdivision and 1 lot that is in the subdivision.
So the vacating
It-
piece is the single lot that's in the subdivision
Yeah,
being
and
pulled out.
it's not, I wouldn't say it's vacating it, but it is pulling it out of the subdivision.
Oh, okay.
Just
I-
combining it. It's not like we are getting rid of it, but it's going to be combined into another subdivision.
Okay. I guess I would assume that would be the difference between the 2 cases?
Yeah, the difference is that these 2 lots on these and the ones that we have going on tonight, they're all in the subdivision already, and we're just combining 2 lots that are side by side. Hughes's is different because there's 2 lots outside the platted.
I don't know if that answers your question.
Not
or
really,
not.
because that
Okay.
was part of the original plat, and so theoretically, any change to that original plat would, according to the way she interpreted it, would have to go through this process.
Okay. I think it's a good question. I guess I don't know the answer. And I guess that's, Mitch, I don't know if you have anything you'd like to add?
I don't.
Okay.
This is a complex question. The Hughes subdivision was, they requested to get all the signatures. That was the state's attorney's interpretation of Century Code for that particular situation, and it is different than this, but it's still a little bit. It's still, I would consider it the same because you're vacating a lot out of a subdivision and you're creating a new one. You're creating a new lot out of this countryside, one out of two, and so it's basically you're vacating one, but this is different because it's within the subdivision. The other one is pulling a lot out of the subdivision into a new subdivision. It's completely different. So, I mean, it's similar, but it isn't. And there's no enabling legislation in Century Code that says you can't vacate these single lots. But it's also very vague on what you can do.
Okay.
And, I mean, we're following historical, before us, all these lots that have been approved. This has never been brought up, never questioned since I've been, and I've asked many planners the same thing. It's a standard procedure to go ahead and vacate the lot out of the subdivision to create a new subdivision. If it's all privately owned, you can do that. That's the interpretation of all the planners I've ever talked to. But we don't have a secondary opinion, legal opinion on this.
Okay. Yeah, I guess to answer your question, no. There has not been approvals from everyone in the subdivision for this.
Okay, is that going to be expected at the next step? Because my take is I want to make sure that this is being applied evenly and appropriately. These new rules that have been created by the state's attorney's interpretation.
And
Mr.
Commissioner
Chairman, I just
Rich,
had a
yeah.
question. I thought we passed your request from this
You did.
body to the county commission, and then the
It
state.
stopped there.
It stopped there? Okay, see, that's new information for
Yes.
me.
Yes, you did pass.
Okay.
But there's no public forum or public hearing at the county commission, so that's why I'm discussing it here.
Gotcha. So, yes, I would say it sounds to me like we have a little bit of a difference in.
A little bit, but as he said, this is vacating and creating a new subdivision within a subdivision, but still vacating and creating.
And I would say, I would just ask Mitch, do we need to continue this public hearing on so that we can get some clarification on that, or not?
It wouldn't hurt.
Don't you?
Or can we make a decision on this tonight without that information?
Mr. Chairman?
Mr. Chair,
Yes.
I do not, legally, I don't have the answer for that question, but this is unprecedented because it's never been held up before. The request on the Hughes subdivision was placed there by previous owners for them to go through that. Now, we've never had this problem before with creating lots within a subdivision or separating or vacating a lot out of a subdivision. It's never happened before. It's unprecedented that you'd have to get the signatures of all those people, unless you want to vacate the entire plat. That's how I read Century Code, but they're not vacating the entire plat, they're vacating one lot, or two lots in this case,
Okay.
and creating one.
Okay. Commissioner Patrick, you had a
Well, I'm
comment?
just wondering if maybe, I was going to ask Mitch, maybe we need a legal opinion on this.
Yeah, I'm not an attorney,
Would you,
but I would say that this is very normal procedure to create
it is, I
a
think we've
bigger,
done this
a
before.
larger lot in a subdivision. It happens all the time.
Yeah, we've done this before.
I mean, it
All right.
happens within the city without a plat.
Yeah, Commissioner Strickle, yeah.
Can I ask, why is it stuck at the county commission? What is the status? What happened?
Because the finding was that we first have to vacate a plat or part of a plat, not, even though that's what Century Code says. And that in order to do so, we have to get the signature of every property owner in that plat. And so I'm still in this process.
Okay. Yeah, Commissioner Patrick, yes.
Well, I just want to clarify, in your situation, you were actually vacating a lot in a subdivision and taking it outside that subdivision, is that correct? Isn't that correct?
It was creating a new subdivision. This is
Right.
creating a new subdivision as well. Even though it's within the subdivision, it's creating a new.
Well, this is combining two plots within a subdivision is the way I understand it.
Yeah, this is not a new
This-
subdivision.
No, it's not a new subdivision.
Mitch described it as vacating two lots within one subdivision and creating a new subdivision within that.
No, that's not what
That's
we're
not
doing.
what's going, yeah.
What we're doing tonight is different too. Combining these lots is we're using Article 33, Section 12, where we're creating a new subdivision, but it's really just a lot combination like the city of Bismarck does, and we just call it a minor plat. What Hughes's would be considered a major plat. So.
Which has been done many times prior to
Yeah.
mine, correct?
Yeah, we've done these kind of things since we put Article 33, Section 12 was voted in, like a year ago, maybe two. And we've done this, but all with minor plats. And that's where we ran into Island Road, where they were concerned about the covenants. So we had them sign on to the covenants with their newly created one. So they're all minor, but this is a major plat. So,
Okay. All right, we will do the best with the knowledge that we have tonight, and should there have to be other things that happen with it in the future, then I guess, that may have to happen. I don't know.
Okay, so is there going to be a legal opinion on this? That's my question.
I don't think so, no.
Okay.
Not from our standpoint. Once it goes to the county commission, I can't say.
Okay. But I also have no room to object at the county commission or express concern. That's why I'm asking now.
Yeah, Commissioner Conley?
Actually, you do, because with the passage of Senate Bill 2180, which codifies everybody's opportunity for public comment based on the county's ordinance for that, you can speak on any item on the agenda.
Okay.
So definitely, feel free to use that at the county commission.
Well, let me take that a little
yeah,
bit further,
Commissioner
okay?
Bittner,
I'm
yes.
currently the chairman of the Burley County Commission, and you're welcome to come in and speak, okay? We don't make it a practice of eliminating public input,
Okay.
so I don't think that's a problem. Your situation is totally different than this one.
In some senses.
But I think we're going to get an attorney's opinion in the meantime, anyway. So just so you know, that'll happen, but it doesn't have to happen at this table.
Okay.
I appreciate the concern, thank you. Anyone else like to speak on the Apple Creek Ridge second subdivision? Anyone else like to speak in this public hearing? It's the last call. Seeing none, we will close the public hearing and move into discussion and action.
Mr. Chair.
Yes, Commissioner Patrick.
I'll move to approve.
Second.
Okay, it has been moved to approve by Commissioner Patrick, seconded by Commissioner Munson. Is there any discussion on the motion? Seeing none, we'll move into a roll call vote. Marla, if you could take us through that?
Okay. The motion is to approve the subdivision and give it a due pass recommendation. Commissioner Small,
Yes.
Commissioner Rich,
Yes.
Commissioner Bittner,
Yes.
Commissioner Conley,
Yes.
Commissioner Streifel,
Yes.
Commissioner Patrick,
Yes.
Commissioner Munson,
Yes.
Commissioner Jarrett,
Yes.
and Chairman.
Yes.
All approved.
Okay, the Apple Creek Ridge second subdivision will move to the county commission with a due pass recommendation. We'll move into our third public hearing of the evening. It is the Aberley fifth subdivision. And looks like Marla is back up again and going to give us some details on this before we open the public hearing.
Okay, this is the Everly Park Fifth subdivision, and they are requesting a zoning change. So there's two items tonight. Aberley Land Company is the petitioner. Swenson Hagen and Company is the engineering firm, and it's part of the auditors, Lot 3, Section 28, Township 139, Range 78 West. It's a 5-lot subdivision containing 11 acres, more or less. The zoning change is agricultural. They're requesting industrial. The petitioners are requesting approval of the final plat and zoning change, due pass recommendation. And it was posted February 25th and March 4th. Surrounding property owners, February 27th. Burley County website, February 27th. Burley County was contacted with a proposed 5-lot subdivision on 11 acres, and they requested the zoning change. This is the final phase of the Everly Park industrial parcels, and county staff has reviewed the subdivision and have no concerns. Burley County Planning and Zoning approved the preliminary plat and zoning change on February 11, 2026. Staff findings: this subdivision fulfills the requirements of Article 33 of the Burley County zoning ordinances. The final plat has been submitted to all reviewing entities. All concerns and corrections are made, and the zoning change has been requested. Stormwater management plan has been completed. Staff findings, the zoning change fulfills the requirements of Article 18 Industrial District of Burley County zoning ordinances. The zoning change fulfills the requirements of the Burley County Comprehensive Plan, number 6 and number 8. And the goal is to encourage orderly development in Burley County. Staff recommends for the final plat approval, and they also recommend approval of the zoning change and a due pass recommendation to the Board of County Commissioners.
Okay, any questions for Marla? Seeing none, we will open the public hearing on the Aberley 5th subdivision and rezoning. So if anyone would like to speak, please approach, let us know who you are, where you're from, and sign in.
Hi, thank you. Landon Neimiller with Swinson Hagen Engineering, representing Aberley Land Company in this one. Yeah, as Marla had mentioned, this is sort of that final phase of this industrial area out in Minoka. Everybody's probably been out there at one point or another. That last little piece of land that's to infill the rest of this area. There's one little old green piece you can see on your map there that is not part of the family land. So this is the last of their pieces that they can infill, dedicate that little last piece of right-of-way and develop some industrial lots. I can answer any questions if you have them.
Okay, any questions for Landon? Seeing none, thank you.
Thank you.
If anyone else would like to speak in the hearing for Aberley 5th subdivision and rezone, please approach the lectern. Let us know who you are, where you're from, sign in. And last call, if anyone would like to speak in this public hearing. Seeing none, we will close the public hearing and move into discussion and action on this hearing. I'll remind you, this is a subdivision and rezone.
Motion to approve. Second.
Okay, it has been moved to approve by Commissioner Bittner, seconded by Commissioner Munson, to approve the subdivision and rezone. Is there any discussion? Seeing none, we'll move into a roll call vote. Marla, if you could take us through that.
Okay, this is to approve the subdivision and the zoning change and give a due pass recommendation. Commissioner Streifel?
Yes.
Commissioner Small?
Yes.
Commissioner Rich?
Yes.
Commissioner Patrick?
Yes.
Commissioner Munson?
Yes.
Commissioner Jarrett?
Yes.
Commissioner Conley?
Yes.
Commissioner Bittner?
Yes.
And Chairman.
Yes.
All approved?
Okay, the Aberley 5th subdivision and rezone is approved to send to the county commission with a due pass recommendation. We will get into our fourth hearing of the evening, the Riverside 2nd subdivision replat.
Okay, this is an interesting one. When we first received this, it was called Riverside Second replat. And then, since it's not a replat, it went to Riverside Third. But then Landon informed me today that there's a Riverside Third already, so now it's Riverside Fourth. Because it's just a lot combination of two lots in the Riverside subdivision. It's, Dustin and Ashley Massett were the ones that requested it, and it's lots 11 and 12, Block 1 of Riverside 2nd Subdivision, Section 33, Township 140 North, and range is 81 West, and the address is 9448 Island Road. The project size will be one lot containing 2 acres, more or less. The zoning is R1, Rural Single Family Residential, and they request approval and a due pass recommendation of the lot combination. It was put in the Bismarck Tribune February 25th and March 4th. Surrounding property owners February 27th, and Burley County website February 27th. The owners had contacted us to do a lot combination of 2 lots located in the Riverside subdivision. And they were advised to do a short plat subdivision and to combine them into one lot. And this subdivision fulfills the requirements of Article 33 of the Burley County zoning ordinances. The final plat has been submitted to all reviewing entities. All concerns and corrections will be addressed. And that means we're changing the title. The subdivision does meet the requirements of the Burley County Comprehensive Plan, Article 3, Residential Neighborhoods, Objectives 1 and 2. A stormwater management waiver was not required, and a paving waiver is not required. And the petition for the final plat meets all the administrative requirements of the Burley County zoning ordinances, Article 33, and staff recommends approval of the final plat and giving a due pass recommendation to the Board of County Commissioners.
And Marla, when you said the corrections, you mean just the title being fourth, right?
Yeah.
There's no other corrections.
I think there was one or two, just like minor ones, that he was still getting corrected, but nothing that's gonna affect the plat. He'll have that to me by tomorrow, so.
Okay. All right, thank you. Any other questions for Marla? Seeing none, we will open the public hearing on the Riverside 4th subdivision. I think I got that right. Riverside 4th.
Riverside 4th.
Okay, if anyone would like to speak on this, in this public hearing, please approach the lectern. Let us know who you are, where you're from, and sign in.
Thank you again. Line and 9 Motor Swenson Hagen Engineering, representing them on this one. As Marlon noted, this is basically a lot combination to get up to that 2-acre parcel rather than some of these older county lots are a little under that acre and a half, a little smaller than most people would like now. So a 2-acre subdivision lot is what they'll be looking at here today. As Marla also mentioned, yeah, a number of Riverside subdivisions have already come through since Second was initially created, so we're on to Riverside 4th here at this point. But I can certainly answer any questions.
Yeah,
you have.
what are the corrections, the minor corrections?
Sure, that's a great question. So we've noticed in this area that some of these section corners that we would need to tie the plat to from a distance and bearing situation is those corners may not have been recorded ever, and they may or may not actually be in the ground. So we're verifying that they actually do exist. If not existing, then we're going to be setting them ourselves. So that's what our technical issue is.
Okay, and that's it?
And the title, of course.
And title, okay. All right, yes, Commissioner Bittner.
Thank you, Mr. Chairman. Landon, does it concern you at all that we're doing a Riverside 4th, just as part of combining two lots? You know, combining two lots just doesn't seem to rise to the creation of a subdivision.
Sure, thank you, Commissioner. That's a good question, and it's a recent change, obviously, to the Burley County ordinance. There was a time, probably a year ago, you would have just simply contacted the auditor and asked them just combine them administratively, and they would have just done it.
Yeah.
I don't think there's anything wrong with this new process of doing a combination. I think the city of Bismarck is heading that way as well. So I think you guys will line up pretty well going forward, where it's going to be these minor plats rather than in the past it would have been a plat of irregular description or just a administrative action where if you were not paying attention to these meetings, you wouldn't even know that they were combined if you didn't have a way to track it. So I think this does actually help in that aspect.
Okay.
Mr. Chair.
'Cause I had that done on my land years ago. We had multiple lots, and it's just put them all into one. No big deal.
Mr. Chair.
Yeah, Mitch.
Auditors' lots are fine for combining, but they don't change the subdivision. What happens to the lot line when they give an auditor's lot? It still stays there. And it doesn't erase it just because an auditor created a lot, or you call it a plat of regular description. Platting removes those interior lot lines and creates one lot.
Okay.
That's the difference. That's why we don't use auditors.
That's the difference. right?
Yeah, because if we used auditors a lot, somebody could come along and sell that lot because it's still recorded as a separate lot.
Okay,
Still shows up on that subdivision.
okay, good to know. Commissioner Small, did you have something?
He answered my question.
Fantastic. Anything else? Any other questions? Thank you.
Thank you.
Thanks, Landon.
Anyone else would like to speak on the Riverside 4th subdivision?
Well, I'll save the full discussion, but I have the same concerns with this one. If you'd like me to say that. So, we'll save the full discussion, but same concerns as with the previous one we discussed.
Yeah, absolutely. Understand, and yeah, being that this is in the same subdivision, lot combination, then yeah, I think.
But we're calling it a new subdivision still.
Correct.
So,
Yeah, I think that's, we may need to have to work on that in the ordinance to maybe call out some clarity on that. Absolutely. Any other, and anyone else like to speak in this public hearing? Last call. Seeing none, we will close the public hearing and move into discussion and action on Riverside Fourth subdivision. And I would say if we're gonna move approval, I would say that we'd probably wanna just include the two corrections, or the with corrections, I would say.
I would move to approve the final plat with conditions and give a due pass recommendation to the Burley County Commission. Those conditions being the property pins and the renaming of to the fourth.
I'll second.
Okay, it has been moved for approval by Commissioner Munson, second by Commissioner Patrick. Is there any discussion on the motion? Hearing none. Marla, if you could take us through the roll call vote.
Okay, the approval with conditions. Commissioner Bittner,
Yes.
Commissioner Conley,
Yes.
Commissioner Streifel,
Yes.
Commissioner Small,
Yes.
Commissioner Jarrett,
Yes.
Commissioner Rich,
Yes.
Commissioner Munson,
Yes.
Commissioner Patrick,
Yes.
Chairman.
Yes.
All approved, and I've got the conditions of property pins and title.
Fantastic. That will go to the County Commission with a due pass recommendation. We'll move on to the fifth hearing tonight. This is Holly's Horses Edition.
I'm back. This is the last time. Okay, this is Holly's Horses Edition, and we're at Bruce and Holly Gallagher. I'm not sure if I pronounced that right. They're the developer's petitioner. Independent Land Surveying is Mark Isaac, and this is again a minor plat. It's a combination of lots 1, 2, and part of 3, Block 1, Sibley Island Estates, Section 34, Township 138 North, Range 80 West, and it's addressed as 1712 Estate Avenue. The lot contains 4 acres, more or less. It's zoned rural, single-family residential, and they're asking for a due pass. Posted Bismarck Tribune, February 25th, March 4th. Surrounding properties, February 27th, Burley County website, February 27th. And the Burley County was contacted for a proposed lot combination, and they were advised to do a short plat subdivision, which is up there. This subdivision fulfills the requirements of Article 33 of the Burley County zoning ordinances, and the final plat has been submitted to all reviewing entities, and all concerns have been corrected. Zoning is R1 rural single-family residential, and this subdivision meets the requirements of Burley County Comprehensive Plan, Article 3 residential neighborhoods, objectives 1 and 2. Stormwater management waiver was not required, and a paving waiver was not required. The petition for the final plat meets all administrative requirements of the Burley County zoning ordinances, and staff recommends a due pass recommendation to the Board of Burley County Commissioners.
Okay, any questions for Marla? If not, we will open the public hearing on Holly's Horses Edition. If you'd like to speak on this hearing, please approach the lectern. Tell us who you are, where you're from, and sign in. Anyone like to speak in this public hearing?
Again, I have the same concerns. I mean, this is combining and creating a new subdivision, and we're not asking them to require or to get the authorization of everyone's signature that already is in the subdivision. And it's not even named the same subdivision in this case. It's got a new name. So.
Yes, absolutely. I definitely think we need clarity on this. So I appreciate you bringing it up. I really do.
Okay.
Anyone else like to speak in this public hearing on Holly's Horses Edition? And last call, anyone like to speak?
I'm Gary Nelson. I'm in that same subdivision. I just had a question on, we haven't been assessed for our road that's out in our neighborhood, and they basically just said that they would repair it, but if we were assessed, is that according to our lot sizes, or is that according to the number of lots that we have in the subdivision?
I think it's both.
It's both.
Yeah, I think that there's two parts to it. The number of lots that you have comes into play more when you're determining the special assessments. And then the amount of the land creates the amount for the special assessment.
Is that the frontage?
The percentage of ownership, I think, applies for the special assessment district. Like if you have to sign a petition.
Okay.
All right, so is that clarified?
Yeah, because I know there was talk amongst us of what is the advantage of putting, if we have multiple lots, is it an advantage to put them together as one? Or is it, or does that change anything in doing that?
I'm not aware of that being a benefit either way.
Either way?
Yeah.
Okay.
Because ultimately, it's based on the amount of land.
Okay, so my question is, are these lots being combined and then separated from our subdivision, or are they still part of Sibley Island Estates?
Marla, if you could answer that one?
They are still part of Sibley Island Estates. It's just that she requested to change the name to Holly's Horses Edition, but you're still part of it.
Okay. That's it. That's all I had a question of.
Thank you.
Thank you.
If anyone else would like to speak in the Holly's Horses Edition public hearing? Okay, seeing none, we'll close the public hearing and move into discussion and action on this hearing.
I'll move we approve the final plat and give a due pass recommendation to the Burley County Commission.
Second.
Okay, it has been moved for a due pass recommendation by Commissioner Rich, seconded by Commissioner Munson. Is there any discussion on the motion? Okay, seeing none, Marla, if you could take us through the roll call vote?
Okay. Commissioner Munson?
Yes.
Commissioner Jarrett?
Yes.
Commissioner Conley?
Yes.
Commissioner Bittner?
Yes.
Commissioner Patrick?
Yes.
Commissioner Rich?
Yes.
Commissioner Small?
Yes.
Commissioner Streifel?
Yes.
And Chairman?
Yes.
All approved.
Okay, that is approved, and that will move to the County Commission with a due pass recommendation. We'll move into the final hearing of the evening on the Ainsley Special Use. And we get Mitch this time. Fantastic. Mitch, if you could take us through the details?
Good evening, Commissioners. We have a special use request for an oversized accessory building. This is out at 11515 Edgewood Drive. It's a 1.05 acre lot, 45,000 square feet basically. And they're asking for an allowance of up to the 3,000 square foot building. There is no primary structure on the building. So it's a single lot by itself. The owner lives, I believe, right across the street, and they want to build an accessory building. I'll get it on the. It's roughly a 60 by 50 square foot building. This is the Edgewood side. It's basically the single garage. It's got a large garage door and a small one. And that's a 50-foot width building. There's an existing accessory building there now, and they want to tear that down and build this right in its place. We've had no comments from anybody, no opposition to this. The normal allowance for this size lot would be 1,800 feet, but that's for they want to go to a 3,000 square foot building to house their toys. I stand for any question. It is in the floodplain. They have to elevate. Well, it depends on what their elevation certificate finds. I don't think that they'll have to because it's already, according to my map, it's already 5 feet above the BFE. I don't know why it's in the floodplain, but it's mapped as such, so.
Any questions for Mitch? Commissioner Rich?
Mr. Chairman, Mitch, it's called an accessory building. Doesn't it have to be accessory to something like a home or something? I mean, why do we call it that? I don't have any problem with the issue, but it just seems
That's
like-
what they're described as. They're not a single-family resident. They're not for residential use. I'm not saying that he can't in the future get a permit and put a bathroom and kitchen in this. But they're called accessory buildings because they're accessory to the primary structure. And we don't relabel them just for this particular application because it's still an accessory. It's not the primary structure.
I'm
It's a-
agreeing with the confusion on that.
It's an accessory to a home on a different lot. Is that what you're saying?
Right.
Yeah, I mean, you could say that. We do this quite often, though. They build their accessory building first, and someday they'll build a house there. I don't know.
Is really accessory building just saying it's not a residence?
Yeah, we do not want to call it a primary residence,
Okay.
because then they could put another accessory building there. So the idea is that you have to describe the building somehow. I mean, technically it is an accessory building to the primary structure, but the primary structure here happens to be across the street. But there's some that we've issued permits for, they don't even live there. Some of them live right next door. So it happens quite often.
Commissioner Bittner? Yeah.
So there's nothing in the ordinance that says there has to be a primary structure before you do an accessory building?
There's nothing that says it has to be, but if you want to build the accessory building prior to the single-family home, you don't have to get a special use permit. You just have to get signatures from 60% of the people that live there now. The special use permit for here is because it's oversized. If they didn't get the special use permit, they would be restricted to 1,200 square feet.
And if they were going to build something 1,200 square feet, they would have to get signatures from 60%.
And I think they're getting.
So they have to get the signatures anyway.
They did get the signatures already.
Okay.
For allowing accessory building on the
Right.
unattended lot, so.
Okay, that's good to know. Yes.
Yeah.
The intention of this in our ordinance is to keep people from building an accessory building, calling it an accessory building, and turn it into a shop and start working on trucks and cars. And living on the other end of the neighborhood.
Yeah.
They don't want people to commercialize these buildings, use them for work and that sort of thing.
Any additional questions for Mitch? Yeah, Commissioner Rich.
It just seems like it's kind of interesting that they only need 60% of the signatures and the gentleman in the audience needs 100%. 100%. All you need is one person it's a different issue, don't get me wrong.
Yeah.
But I mean, 60% is somewhat reasonable. 100%, you get somebody that just says no and you're out of luck.
Any other questions for Mitch? All right, Mitch, seeing none, thank you. We will open the public hearing on the Ainsley Special Use Permit. And I guess just remind me, what is the city in the ETA? What is the lot coverage percent allowed? Do you remember?
4% lot coverage?
4%. Okay. Doesn't. just for my information.
Hello, Commissioners. I'm Rob Ansley. My wife, Lisa, and I, excuse me, own that piece of property. We live across the road. Our primary residence is there. And so this is just, the intent of this building is a shop to hold tractors, snow blowers, mowers, all those things you need when you live out in the county. So I'm just wondering if anybody had questions for us.
Any questions for Rob?
No, I think, Mr. Chairman.
Yeah, go
Mr.
ahead.
Chairman, I think the big thing was just making sure your neighbors are okay with it.
Yeah, we had 80% approval.
Yeah.
Basically, everyone I contacted said, no problem. That's going to be better than what's there now.
Yeah, I understand.
Okay, thank
Any
you very much.
additional questions for Rob? No, thank you, Rob. If anyone else would like to speak in this public hearing on the Ainsley special use, please approach the lectern and let us know who you are, where you're from, and sign in.
You know, my name is Dennis Wetzel, and I don't have a problem with this, but I have a question as far as what are the rules? Because a friend of mine just told me at a funeral the other day that he has a lot up in Grand Prairie. He wants to build a garage. He's told it's less than 1,200 square feet, and he has to get permission from everybody a mile in that jurisdiction from that lot. So, that's not right?
Is Grand, just a question, is Grand Prairie, is that in the, was in the transfer area, I guess, yeah, it was in the ETA, right? Was that quoted before it moved to the county or after?
No, I've never.
Well,
heard of-
this was before.
It must have been before, so I think that the answer to your question is that the rules are changing.
Okay, so
Or,
I should have him come in and talk to Mitch then, I suppose.
I think it would be worth his time to maybe reapproach, because that's going to be a little bit different, not being in the ETA now.
Because he doesn't have a house there, it's just a lot, he lives in town, and he wants to build a shop out there.
Yeah.
So,
Yep, so you're asking about the rules. The question is, the rules are changing. Yes. Thank you.
Oh.
Any other input? Anyone like to speak in the Ainsley special use?
Mr. Chair, I would say that to his answers, we do require a quarter mile for if you're going to do an accessory building such as this. We ask for signatures within a quarter of a mile.
And that's 60%?
Not a full mile. And 60% of those
60% quarter
people
mile.
in a
Okay.
quarter mile.
Gotcha.
Yeah, that makes sense there.
Good to know. Anyone else like to speak in this public hearing? On the Ainsley special use, last call, if anyone would like to speak. Seeing none, we will close the public hearing and move into discussion and action on the Ainsley special use.
Motion to approve.
Second.
It's been moved by Commissioner Bittner, seconded by Commissioner Munson, to approve this with a due pass recommendation to the county commission. Is there any discussion? I think this is a really interesting one, leading into all the changes that we're going to be looking at. So this would be 6.5% lot coverage and I mean a 3,000 square foot. So I think that's a good one to kind of keep in mind as we move into the discussions on the changes to the ordinance.
Yeah.
Any further discussion? Seeing none, we will move into the roll call vote. Marla, if you could.
Okay. The motion is to approve it. Commissioner Jarrett,
Yes.
Commissioner Munson,
Yes.
Commissioner Patrick,
Yes.
Commissioner Rich,
Yes.
Commissioner Small,
Yes.
Commissioner Streifall,
Yes.
Commissioner Bittner,
Yes.
Commissioner Conley,
Yes.
and Chairman.
Yes.
All approved.
Okay, that is approved. The Ainsley special use is approved with a due pass recommendation to the county commission. That concludes our hearings for the evening, and now in other business. We have, obviously, kind of extending on to the discussion we've had in the past. Mitch was nice enough to kind of get this down into some bite-sized pieces for us, and talking about some of these pieces and these zoning comparisons. And as I understand it, Mitch, what you're really looking for is that how we want to craft the text and the language so that we can kind of address these one by one and know what we want to have for the language in the county ordinance.
Correct.
Yes.
I've broken it down to zoning districts, ag, floodplain, R1, R5, C, I, PUD, and P public. There's some, at the introduction, there are some facts about what's changing in our ordinance, or changing in our jurisdiction. We're almost doubling the size of the amount of people that are in there. The idea is on page 4 of your packet of this part of the agenda. It describes the minimum lot size, and it describes some of these zoning jurisdictions and what their purpose is. We're not going to go into all those R districts because that was way too much for you guys. So, and we'll someday have to adjust some of those because there are quite a few parcels that won't fit into these jurisdictions, but they're not as many as what we're talking about tonight. The first up, staff report 6.11, is the floodplain districts. It's on page 5. I brought this up because there's the difference between the city of Bismarck and Burleigh County is fairly large. The idea is the city of Bismarck does not regulate to 2% or 500 year. We recognize it as a special flood hazard area, and we regulate and require the 2-foot free bird like we would do in the 1%. So we regulate both, whereas the city regulates just one.
And I guess on that, I guess maybe just from the commission here, I really what do we want? Is 1% what we want in there, or the 0.02%? Because that's the difference. So I mean, if we keep it the same, it's the 0.02. If we say, okay, well, we want to do really what the ETA had in it.
You have the choice of removing the 2%, the regulations, like the city, or we do both, which we are doing now for the entire for most of Burleigh County that we regulate. In our jurisdiction, we require both floodplains to be regulated, and that's a very important fact too. We did that long before I got here. Burleigh County did. And the purpose of it was because these flood maps change, and they weren't very accurate back in 2014 or 2004, or even back into 1977, I think was the one back, the very first one. And so we have areas in the county that were in the 2% of the 500 year are now back into the 100 year, 1%.
Do you mean the 0.2 of 1%?
Yeah, the 500 year,
okay.
0.2.
Right.
So the idea is that if we remove that, one idea is that what would happen to all the people that we required to elevate before? Mm-hmm. I guarantee they'd be pretty upset.
Right. You wouldn't require them to take out the elevation, but
when I was in Minot,
regulations change all the time.
Right.
So
when I was in Minot, we didn't regulate 500 year, and when I got here, I said, "Whoa," because it's a lot more work, but it makes our jurisdiction and our community more resilient. Absolutely, because these flood maps will change. I'll guarantee you the 2024 map, it's going to be different when they come out in 28 or 34 or whenever they come out. I'll guarantee you they're gonna be different. And so, it is more restrictive, but I don't recommend changing it.
And I guess I would just ask the commission, I mean, are we on board with that? Do we want to keep the 0.02, I guess it would be the 0.2%, or just have the 1% as the Bismarck, I guess the ETA would have had in it prior? That would mean that the 1% would apply to the entire county, not the 0.2%.
Right.
Right.
Mr. Chairman.
Yes, Commissioner Bittner.
I think one of the problems that we run into, and what I've heard about lately, is that somebody that was in the ETA built their house to that particular flood elevation, but now that they'd be into the county, they'd have to go to this new elevation that was not what they were under before.
Yeah.
So it like,
On new
it's like you
construction.
gotta,
Yeah.
no, if you have, I think the issue was like, if it's more than 50% of the property value or something. There were some catches to it, but what it amounted to is you'd have a house that your floor is here, but your addition, your floor is, I don't know, somewhere else. And that's the kind of thing that I think we need to be aware of. And, the goal with doing the ETA was not to make people have to do something they weren't already having to do. That seems like a negative, even though, and I agree that it makes us more resilient with flooding, and it protects people to a higher elevation. But this is one of those things, kind of an unintended consequence that I'm not real comfortable with.
Yeah, because really, it's the difference between the 100-year floodplain and the 500-year floodplain, right? Is that how I read it?
Yeah, Mr. Chair, our ordinances allow an addition to an existing building at the same elevation as that floor, as it is, up to 50% substantial improvement. So we get calls all the time. We get calls on a garage. I got a call today on a garage. They want to add on to their house. And I said, well, you can. You just have to document the valuation of it, and you can't go over 50%.
Okay.
And that's how that works, and even on a regular addition. Doesn't have to be a garage, could be any kind of addition.
Mm-hmm.
But the thing is, on a lot of these older homes, they were built 20, 25 years ago. We don't know if they were built to the ordinance at that time. And even if they were built at that time, they would still only be allowed 50% even in the city. Even in the city. So it's
Right,
kind of.
right. So if we do keep the 0.2% of 1%, which is the 500-year, basically the 500-year floodplain, right, on there, that would mean that any additional building that goes on, or in more than 50% of your value of your house goes on, those in what was the ETA in the transfer area,
Yes.
they would have to build higher.
If it's past it, yes.
Right.
If it's more than a substantial improvement, which is the 50% mark, then yes, they would have to bring that house up to,
Okay.
if they want to do any work.
So what's the thoughts here? I guess Commissioner Rich.
Thank you, Mr. Chairman. Thank you, Mitch and Marla. You did a really nice job of putting this comparisons together. Appreciate that. What impact does this have on someone buying flood insurance? Or isn't that a factor at all? I mean, that's one of the issues. I lived on the south side of Bismarck, and I bought flood insurance just because I was on a 500-year floodplain. But
Yeah, Mr. Chair, the flood insurance not requires, or it's not mandatory in the 500-year. It is in the 100-year. You can absolutely buy it if you want, but it's not a mandatory NFIP requirement.
Yeah. So basically if we said we wanted to keep the 0.2 of 1%, that means anybody in the transfer area that is going to improve their home by more than 50% of the value, or any new buildings, are going to have to basically go raise to the 500-year.
If it's new, yes.
And
If it's
the 50,
existing.
and the over 50%. Yeah.
Or over 50, yeah, if it's an existing house, you get up to 50% value, same level.
Right. Okay.
If it's a new house, it has to be elevated.
Okay. Yeah. Commissioner Bittner.
How much of an elevation difference are we talking about?
The freeboard's 2 feet on both zones. So the elevation depends on the BFE. We don't know if if we had a BFE, we could determine how much elevation it's gonna be. We're talking out on Hogue Island, they would have been about 8 inches higher if they elevated to the freeboard, to the existing house. Because those flood maps changed. Not because, the ground changed or the house changed, but because that floodplain changes. And it's not just out there in Hogue Island, it's gonna change everywhere again. And so these things are not a static, try to, hold on to this in 10 years is gonna be the same thing. Because in the next round of flood maps, we're gonna have all kinds of different elevations. And you're in the 500 year now, you will be in the 100 year, whatever they decide, whatever they determine. So you got to look in the long term for some of this stuff. And it's just ideas that, now, another thing I might want to add is I don't know how the DWR, the NFIP coordinator, is the North Dakota Department of Water Resources, I don't know how they would respond to us reducing our ordinances. And, I don't know. If we remove this 2% just in the ETA or do with the entire county? That's the question. So if we're not,
So thoughts on this? I mean, are we on board with saying just keep the 0.2% and just keep it at that, which is what the county was at anyway?
Mr. Chair.
Commissioner Munson. Yeah.
I mean, if we're talking 8 inches in the Hogue Island example.
just that one example.
That one example, we're talking 8 inches, going from the 100 to the 500. That's it.
No, it's either one, the 100 year or the 500 year. The elevation is still the same.
Still, okay.
It doesn't, I mean, it's, the 500 year is a less hazard area. It's considered less hazard.
Right.
And the ground elevation changes is noticed, not the BFE or not the elevation requirement. So it's, I don't know, it is less restrictive. You don't have to have insurance in there, but we've, in the past, have required it. And I don't know how this will affect, I don't know how, for one thing, if you just did the ETA, then you'd have to have a separate ordinance for that. Or we'd have to change our ordinance just to fit the ETA then. Or change it for the entire Burley County. And honestly, we're gonna get into legal water if we remove that 500 year for the rest of Burley County. Because
I
we
just
made
wanna
them elevate.
Remind everybody that what we're doing tonight is just giving Mitch input on crafting something to bring back to us. We're not, we can change it.
Yes.
When the actual,
Right.
when we're going to be voting on this. So to me, it sounds like we should just keep the 0.2%. And I mean, we got a bunch to get through here, so I think if we just say, go ahead, keep that 0.2%, and then we can move on to the next thing.
I would agree.
So I think we can move to that 6.1.2,
Okay?
which is ag district.
Yes, the ag district. The highlighted areas, you should have highlighted areas in your packet.
Mm-hmm.
Those are the differences primarily. It's the big ones for the ag, to me, it's not the animal feeding operation of the 10 acres. It's down on the home occupations. You can have up to 3 external employees, up to 50% of the primary home and 100% of the accessory building. You can have a sign of 3 square feet, sales, sales are allowed. And these major and minor home occupations, they're allowed by right. You don't have to get a special use permit. So that's the big difference between ours. If you look at ours, you have no external employees.
And so temporary sales and what is called out in home occupation, which is different than, it would be a change from no external employees up to 3 external employees. And then the 50% of primary home and accessory building and maybe some different signage, things like that, but sales allowed, right?
And
So it says sales allowed, and then it also says temporary sales allowed.
yeah, unless it causes a traffic problem.
So does it just then say sales allowed? You can just get rid of that temporary piece, right?
You could, yeah. I mean, but yeah, absolutely. The idea is the city worked pretty hard on this, and they had a lot of involvement. And so it probably is one of the most extreme home occupation zonings in the state.
Extreme, what do you mean?
That would allow this to happen.
It's very allowing,
Oh, yeah.
right? Okay.
Yes. There's nobody else like it that has this.
Okay.
So but it's important to the people of Bismarck, important to the people in the ETA.
Commissioner Conley, you had something?
Well, out of respect to the county, Commissioner Bittner, you sit on that board on the planning and zoning. And a lot of it is that there's a lot of people that have home occupations that never went through the permitting process, the paying of the $700 and at the time. And that was a point of contention because county residents paying the city fees for listing that. And when I checked in on it, the city was only averaging about $2,100 a year. So there was a lot of people opening up businesses that were going unreported and all in this ETA area.
Yeah. I think the thing is that we're talking purely the ag district right now.
Yeah.
So this is just ag, but in commercial, I think it's called out also.
Right.
But yeah.
Well, I'm just kind of highlighting on some of the stuff that I remember Commissioner Bittner talking on and stuff. So I don't know if you want to add to the context of that, because it was a lengthy discussion. There was some long public hearings. I've watched all the meetings and that, but it is your area. So I don't know if I want to go into interpreting. I fight pretty hard for the ETA residents. So.
Yeah. I don't have a lot to add, just simply that a lot of people are operating commercial things, startups and whatnot out of their homes, and in my case, I did. I've got more land than most, and you can't tell because I got such mature trees and all that, but years ago I did. And, places like Apple and companies like that, some of the biggest heavy hitters in industry today started in people's garages. And so a lot of it had to do with allowing people to start someplace, because not everybody can afford to go down here and buy an industrial lot in one of these subdivisions like the one we approved earlier and make a start. You got to get started someplace. And that's basically, I think, what it really boiled down to. Is nobody wants to see a company like this that this would allow in a normal subdivision. I don't think. This is something in the ag where your neighbors just aren't that close. So it's a little bit different. I think the conversation's different. Certainly, if you're in a subdivision, I wouldn't advocate for a company the size of mine being in a subdivision.
In like an R1 or R.
Yeah, I would think that would be not appropriate, But on my place, you can't even tell, nobody can see it. And it's always been that way. But it's a fairly good sized, I think we're 18, I'll say 18 and a half, but it's actually 18.486 acres now. So,
So
does that answer the?
In ag, that would be, so if we said we wanted to do exactly what they were doing in the ETA, then that would mean the whole county would have the ability to have, up to 3 employees and sales allowed. This kind of gets back to, I guess, remember the one we had, was it last year? We had the Burnt Creek Farms. Let's use that one as an example.
Right.
Would that then allow something like that? With the sales allowed? Now, what includes sales? Or does that mean that, okay, we allow it in ag, but if you're not in ag, then you have to then be commercial? Or, kind of where do we draw that line between that and what has to be commercial?
Mr. Chair,
Yes.
the Apple
Burnt
Creek Farm.
Yeah.
That was they wanted more of an agricultural, commercial agriculture.
Yeah.
And they would have employees, but it's not would not be a commercial event like I don't know, like an event center type thing.
Yeah.
Charging people to come into their property and be entertained for whatever all that stuff. That still requires a special use permit. This is for somebody who owns a small business. He can have his employees there. They can show up in the morning, get all the stuff out of the garage and drive to the job site.
Yep.
But it also allows for sales.
Yep. That's kind of where I was getting at, is that, you know, if you're
100%
going
of
to have.
if you, like this guy that built a 3,000 square foot accessory building, he could turn that into sales. Have 3 employees.
And I guess another reason that I bring it up is that yeah, I see that is in the ag piece. It is also in the R1 portion. And I just kind of think, like, I look at this and I'm like, well, if this is such a, it seems to be a point of contention that we've gone by in the past. And should maybe that be in the PUD? Like, we pull it out of ag, we pull it out of R1, and if you're gonna have employees or anything like that, does that then fall into PUD? I'm just throwing it out just as a suggestion, because then it's more of as like a case by case. But yeah, Commissioner Bittner, or yeah, Commissioner Rich, I think you were first.
Thank you,
Yeah.
Mr. Chairman. Mitch, well, we worked on ag recreational. If we adopted this, could you build a corn maze with 3 or less employees?
No, this has nothing to do with agricultural recreation. This is employees.
But it
that
starts
you
to,
can
it
have
starts
show
to
up.
get into it though. Like,
It
it's-
does, you're right, it does, but it's no, that's a commercial, that is more along the lines of commercial, the recreational entertainment, you know, to invite complete strangers on your property, charge them the money, and then entertain whatever you're doing.
Yeah,
Well,
Commissioner-
this would
oh.
allow 3 employees in sales. That's inviting people to your,
Well, these employees, I
Property.
don't think they'll be entertained. So,
I don't know.
I think they're working there for working, so it's different. I don't know, but this is allowed in the city.
Yep.
And there are people here, that were here at the last meeting that were looking at this heavily too.
Yeah,
I think-
Commissioner Bittner, you got a point
Yeah,
here, yeah.
I think we need to slow down just a minute here. It has never been my intention, and it's never been where sales were allowed, you know, because that's what increases the traffic and disrupts neighborhoods and whatnot. And with my company, we don't sell anything off the premises. You know, it's like he said, if somebody shows up there to get a truck and a trailer and something and then go to work someplace. And I don't think, I really struggle with the sales allowed, because it says sales allowed unless traffic problem. Well, it's almost always going to be generating traffic that the neighborhood may not appreciate. You know, I think that was the biggest thing with the Burn Creek Farm issue, was the traffic and the condition of the roads and the one-way in and all those sort of things. So I would certainly urge caution on that sales allowed thing.
Commissioner Conley?
Well, if I remember right, because I watched the meetings in that, with Burn Creek Farm, they were talking 50, 75, 150, 250, because you're talking larger events and that. And that's where the agritourism came up, or like even in Bismarck, say, on Main Street, the 1603 or whatnot, it's limited to 23 events a year. So, but we have, there are limitations, that's kind of a whole different thing. When it talked about sales like this, where people selling sourdough out of their house, or say some taxidermy to where it's, or you know, like your MLM, they weren't having parties per se, and that it's just one customer picking up a nutritional product, and that was a lot of the stakeholders that were sitting in the area that they weren't reporting. But some of the things that came up, like my wife's a government employee, she works from home, but she would also be subject to that home occupation once the COVID rules change. She wasn't selling anything, she was just working. So those are some of the little nuances that came up, and part of the reason for the change. It's a lot of this stuff is going on, and I would presume it's going on in the county, just nobody knows about it. Because we figured that, that's why I mentioned the $2,100 a year. Some people were doing their due diligence and reporting, 3 of them a year. And there was an estimate, there was between 5,000 and 8,000 of them out there. It's, how do you know? But there are definitely areas of concern because everybody in the neighborhood, if all of a sudden 50 cars show up on a repeated basis, all of a sudden, is there a mechanism to where that trips to where it could be a case by case? I don't know.
I think there needs to be something like that.
Yeah.
I mean, you can't just say sales allowed. Because now a guy like me, I would do a Amazon warehouse because it's all robot controlled, but look at the trucks that would be rolling in and out of there.
Right.
You know,
So if we.
I mean, not like me, I'm not going to do that, but you know what I'm saying.
In ag, so if we even said, okay, Mitch, what if we changed it to 3 external employees and said the 50% of the primary home, 100% of accessory building, sign at 3+ square feet, but took the sales allowed out of there and just keep with the no on-premise sales? I mean, is everyone okay with that in ag district?
That would have been my suggestion.
I think let's put that into the draft.
Right, Mr. Chair, the sales, in our ordinance, no sales are allowed on site, but they are allowed on an advertisement. In other words, they can order it online, and then they transact this online, they come over there to pick it up and go. That's allowed in our ordinances, as long as there's no sales transaction, there's no products there to display, there's no open sales.
And we would call that out as stipulations.
Yeah, that would be, that's
Okay.
allowed as a home occupancy right now in our
Okay.
ordinance.
And-
There are people that sell guns online.
Yeah.
And they live in these residential houses and they transact that over the internet, and they just come by and pick it up and they leave.
The thing I want to get back to is that now in agricultural, it says temporary sales of certain items are allowed. And that was in the transfer, what used to be the ETA. I guess what would you consider is a temporary sale? I mean, if somebody said, well, I'm selling things, but it's temporary, well then, what is temporary?
Like a yard sale?
Yard sale, garage
Is,
sale.
I mean, do we limit them to number of days, number of hours per day? I don't know. What's temporary?
We don't limit it. I mean,
Yeah.
there are people that have yard sales every weekend in the city.
I only
But-
ask because that was allowed in the ETA, but it's not allowed
Right.
for the county. So,
Right.
I think I don't see a problem with it, because if someone wants to set up they have their sweet corn stand by the road, and it's purely just, you're not probably not getting a lot of traffic, and it's seasonal, and
Right.
I would consider that temporary, but I
Yeah.
think there would have to be, if we would put that in there, we're gonna have to tell people what is temporary.
We'd have to define temporary in the definitions.
But I don't know if anybody, is everybody okay with that? If we would say we could pull that temporary sales of certain items into our ordinance?
Well, you could have.
Yeah, Commissioner Patrick,
You could
yeah.
have someone, for instance, someone that's raising corn, and in those 2-3 weeks of the year when the corn is ripe, they're gonna be selling, corn to people. Same thing with strawberries. You'd be doing it with strawberries, there's just a few weeks in the year when that stuff is available. And, they're gonna be selling it. So I think that it would be something that I think we'd wanna consider putting that in there.
Seems to make sense,
Isn't
yeah.
that already in our ordinance?
It was called out as a difference here in ag.
In ag,
In
temporary
ag.
sales, that's in the Bismarck.
Right, it doesn't, it's in the Bismarck, but not the Burley.
Right.
Yeah, Commissioner Small?
First of all, I need to know what we're affecting. Is this to change the ordinances in the whole county, or just the ETA that
County.
we took back from the city?
Whole county.
It would affect what is county prior and what is the transfer area, which is now in the county, or controlled by the county, so yes.
Well,
It would
So
be,
a
it would be
farmer can't
both.
have more than 3 employees?
In ag district, actually, right now, on home occupation, Burley County says no external employees at home occupations.
Right, but that
But is not.
agricultural business is separate.
Yeah,
There's
it's
a
not a
different
home
code for selling corn on the side of the road, for employees coming to and from work. That's a whole separate ordinance.
Well, it better be.
Because
Or my brother's gonna come down on me, that's all I can tell you.
Well, I know when we were talking about the ag tourism side, we had that ordinance out making sure that sweet corn sales on the side of the road was legal. They call it was it a truck?
Truck farm.
Truck farm. So, yeah, that's a whole different ordinance.
So what are we talking about right here? You're
That-
talking about on page 8?
Yep.
Okay, so,
Home occupations. Yep.
So,
okay, and so
In
this
your
is
house,
for
yeah.
everybody except the farmers then, is what you're saying?
right.
If you're working out of your house, so like you have a business in your house, yep.
So it'd be like Bitco, you know, this would cover Bitco to be legal, is that correct? Because are you registered as ag?
My land is.
Your land is,
Yeah,
yep,
my land is.
yep.
I've added some that's rural residential, that's 2 lots on the far
Yeah.
north end that are
But Bitco is on ag.
ag.
And so really this now makes what he's doing legal.
And like
But we don't
small
sell.
sanitizing
You don't, but yeah, we wouldn't have to
businesses-
worry about the sales side of it.
Small sanitizing business, so that's really what kicked off a lot of it, was a permit. Somebody had their insignia on the side of their trailer. They had the concrete company ready to go. They wanted to build a shop so they could move all their equipment inside rather than having it exposed to everybody. And our planner was out in the ETA, so, oh, it's a home occupation business, denied the permit and prevented that. Well, to move into town and to, say, rent a shop drives the price up that transfers to the customer. And we all talk about blight in our communities and things, and we don't want that. Some of these, just like Commissioner Bittner talked about, is that everybody starts somewhere. And those are the people with lesser incomes or people trying to be more frugal with their money, they're gonna reach out to the companies that don't have a lot of overhead. Well, if we drive all of that into Bismarck to where they have a lot, well, now you're gonna have people that, now they're priced out of that. Tyson Austin was one that spoke at our last meeting, and his is landscaping business, and he does have employees. He does have a shop in town, but some of the stuff he carries with him because of the threat of theft in town, he prefers it on site, so his employees meet there and they drive off. And that's some of the flexibility that was created in the home occupation. This is a new ordinance from last year in the city. A lot of people in the city, you were there, Commissioner Bittner, a lot of the people within the city were not comfortable making this change, but because it brought in so many different people that would be affected, they decided to give them the benefit of the doubt, and if the problems arise, ordinances can change at any time. That's one of the reasons why some of the things are on both the city's plate right now and the county right now that are heated discussions, is because it's elevated to the level that people are asking for it to be addressed differently.
So with, if we say that temporary sales of certain items would stay, would move into the Burley, the 1,000 plus AU, I think that should stay. And then if we said that the in-home occupation, we just take out sales allowed unless traffic problems, just take that out of there and move that in so that it would be move that into the Burley, the up to 3 external employees with the 50% of primary home, 100% of accessory building, sign at 3+ square feet. If we just say, okay, put that into the ag piece, is everybody okay with that?
Yep.
As a draft? Yes. Commissioner Streifel, yeah.
I have a question. This sign of 3+ square foot, does that mean you can basically have a 100 square foot sign?
Please.
What?
Says the guy who sells
So
signs, right?
yeah, what it was before was 1 square foot sign.
That's for Bismarck, or that's Burley County.
That's Burley County.
It's a square
In
foot.
the 3+ though,
Is square
does that
feet.
mean 3 square feet?
Yep.
Or it says 3+, so to me, I would read that as, I could make it 100 square feet.
No, it's 3 square feet. It's 3 square feet. You got 1 square foot, the SF is in there. I'd have to look exactly worded, but
It's the
On it-
plus, it's the
yeah.
plus that I'm questioning.
Honestly, I would like to change that, and I don't know what everybody's opinion is, change it to 8 square feet, because a piece of plywood It's 8 square feet.
32 square feet.
No.
Or
it's
30, excuse
32,
me,
yeah.
32 square feet. The 4 by 8. The 4 by 8. So basically, somebody could use a 4 by 8 piece of plywood.
I can't support that
Or
in
not.
any way. That gets into the category of
Is that too big?
Too much.
Okay.
It's too much. In my case, I think it would have a negative impact on the neighborhood.
Because I just think like, what would be kind of about that sign size we want to go with? Because 3 square feet doesn't really make a lot of
keep in
sense to me.
mind it's
That's pretty small.
Still a home occupancy.
But that's my point.
Okay.
You're not trying to advertise to bring people to your facility. You don't need 32 square feet. 3 is a little difficult if you're driving 55 miles an hour to try to figure out that this is where I need to deliver my product to, but 32
What
is
makes
way too big.
sense? What's the, go ahead. Yeah.
Some of you may already know this, but I have home business. I build kitchen cabinets, okay? I don't need a sign outside.
Right.
My business is,
Word of mouth.
it's verbal.
Yep.
And I, and people know about me and they'll come out and I'm not selling stuff on site. I'm building them and then I haul them out. Nobody comes in. I don't think you need a sign. That's my opinion.
So my question was, the 3+, if I was a business owner and wanted to put up a sign, I would consider that unlimited.
Correct.
Yeah, so if we just took
Well,
the
that I
plus,
couldn't do
if we
something
took the
smaller
plus
than
out.
3.
Well, the ordinance is not written. Let's back up a little bit.
Yeah.
So, we could limit it to 3 square feet, 4 square feet, or a 1.5 by 1.5. I don't
Yeah,
care.
Commissioner Conley.
Well, back to the discussions from back then, they were, a lot of the people, the stakeholders that came in, even if it was temporary signage, we're talking like the little corrugated signs with stakes that you could put in the ground or
Political
take out.
signs.
Or even if it was more of a permanent one, depending on the type of business. Daycares were a lot concerned about the home occupation ordinance. And there's a lot of people that struggle with finding people to take care of their kids. As long as those were included in the discussion to where it's thoughtful and doesn't interrupt the continuity of the county, but even in the rural areas, people are looking, and that's something in there too.
What would be acceptable, I guess? But,
Well, I don't think a bunch of signs is a very good answer at all.
Yeah.
But I do think the question could be answered with a special use permit process. I mean, if you wanted to have a sign and you could convince your neighbors through the special use permit, then that would be
Case
the
by case,
citizens taking action, not us sitting here and going, oh, no, can't do that,
Right. Yep.
We could keep it same as what it is in the county, as 1 square foot.
Yeah, and then,
So, yeah.
And then
And
it would
if
be
you-
special use permit if you wanted to go above
Bigger.
that.
Yep.
Okay.
Yep.
All right. So moving on to.
Mr. Chair?
Yes.
Since we had this conversation earlier, accessory buildings, we're at 4 square feet, or 4% in this ag area. We just approved 6.5, and that wasn't an ag area, but we're listing 4% of your lot for an accessory building in an agricultural zone.
Keep in mind that, I'm sorry, Mr. Chair, keep in mind, that's a minimum 10-acre lot.
Okay?
Right. Sorry. Yes, I glazed over that one, and I think it needs to be more. I think, but Commissioner Conley, yeah.
And maybe it's in another area. We did change ours specific to try to match the county. Is this in relation to it? Because we did change it to 4%, knowing that the conversation may change, so we would just update it at that point.
I want people, I'm sorry.
Yep,
Didn't
go ahead.
mean
Yeah.
to
Go right ahead. Yep.
Sorry about that. I want people to be able to keep their stuff inside. There's more campers, more boats, more toys, more mowers, I just needed more space.
And the folks that I've talked to said, okay, so you're adding up my barn, my lean-to, my chicken coop, my tractor storage. You start adding all of those up if you're doing it correctly, and I can't have a garage to put my tractor in.
Yeah, and
So 4% in the folks that I've talked to is just not enough.
Yeah, I think
know-
on 10 acres, it's probably not gonna make a difference. But on
Mr. Chair,
2-3 acres? it's
10
gonna make a
acres is
difference.
17,000 square foot building.
Yeah, that's a big building on 10 acres, but when you get down less than that, but because
that's fine.
in ag, 10 is not our minimum though.
Yes, it is.
We just approved some tonight that were in
10
ag that
acres.
were 5 acres.
For which product? Which?
They weren't ag.
That was in Apple Creek Township?
Yeah,
Oh.
yeah,
They have
it was
zoning.
5 acres. And it was ag.
That's their zoning.
Yep,
Okay.
that's Apple Creek zoning.
I'm just bringing that one up because it's, if we're gonna say, okay, then we're gonna think about, oh, this is on the 10 acres. Sure, you go to, like you say, 6% is 26,000 square foot building. That's a monster building. But if we're gonna say, oh, well, we're gonna have these smaller ones, well, then we're gonna get down to 4 and 5 acre. Well,
You may
your percentage
have-
gets pretty small.
You may
right?
have an outlot somewhere that's less than 10 acres that's zoned ag. But if they want to develop it and put a house on it, they have to return it back to an R1.
What about accessory building?
For what?
If they kept it ag, put an accessory building on it,
Oh, we would, if it's still less than 10 acres, we would ask them to rezone it, for one thing, to correct that part.
Yeah.
But it's typically, we have minimum 10 acres for all these ag lots. It starts at 10 acres.
yeah. Commissioner Bittner, yeah, you had something.
Thank you. Kind of ask a question as a lead into a comment, but do any of you know why we have that size limitation to begin with? You want to know?
Is it
I asked
access
the
to
question years
Is it
ago.
fire? I don't
Nope. They didn't want people starting businesses out of their garages. Okay? That's how it all started. And we're sitting here talking about home occupations. No. So realistically, what happens in a subdivision is that people build their stuff and plant their trees, and within 10 years, you can't see their yard anymore. You know, you're a pretty good example of it. If you had a whatever size shop behind your house, who would care?
That's right.
You know? And he's in a nice, affluent neighborhood. So, you know, the 4% thing, it really outlived its usefulness because the goal was to stop people from running businesses out of their house, and then we're doing that, allowing that nowadays, right?
You're in
Yeah,
the
so
same,
what-
you're in the same boat. You can't see your.
Yeah.
What do we want to do? I mean, what's the, because we've had how many now in the last year? We've approved, what, I want to say 5 of oversized over the,
Well, and at the city too, because it's bothered me that people are spending money to get the blessing to do a bigger building that everybody needs. Because everybody's cars, you know, like my garage was a 63 model house.
Yeah.
Their garages were smaller, just, you know, well, nowadays you just need more space. And
and when was the last time we disallowed someone from
we
building?
never
oversized?
have.
We have.
That's why I've said before,
Exactly.
that's why I stayed on the city planning and zoning for so
Yep.
long, because I was there to make sure that, do the best I could to make sure that people from the ETA, were, if they came in requesting a bigger building, that was a focus of mine. As well as other issues in the ETA, but that's a big deal to a lot of folks, and I just think size restrictions, I mean, realistically, in these subdivisions, you drive around, you can't see after the trees get up, because everybody likes that. So, I don't know.
Commissioner Small.
Mitch, I got a question for you.
Sure.
What does a variance cost?
$250.
$250? So if they build a building, don't you get paid for the building permit?
Yeah.
So why are we charging them $250 for that?
For a public hearing. We don't make any money on it. We have to send out advertisement, we have to send out notices and letters to all the people. And we have to hold a public hearing. And like I said, advertise in the paper twice. So we're losing money on that $250. But I would suggest, back to the accessory buildings, I would suggest maybe an increase per the size of a lot. Instead of just one flat 8% or 10%. Because we're seeing, I'm thinking we're seeing we're seeing an average of probably 3,000 to 8,000 square foot on these residential accessory buildings. The one tonight was 7,000.
No, this is ag, so.
I understand. We're talking about accessory buildings.
We're assuming that 10 acres is the
Yeah.
bottom of ag, but it
Right.
really isn't.
Well, well, you guys got a question on what should we have, what should we do on these accessory buildings? I think that maybe you could increase them size, the minimum 4% to 5% for, say, a lot that's 3 acres, 5% for a lot that's 4 acres. I don't know, but we'd have to come up, and we can determine it that way.
Because R1 is down to, is it 2?
4%.
No,
2 acres, yes.
Acres, 2 acres,
Well,
right?
65,000 square feet, but
Sure.
yeah, that's an acre and a half.
So I don't know. Do we want to change that to more for ag?
I think it needs to.
Yeah. Because where have been our the ones that we have approved? Have they been? I know some have been in ag. They haven't all been in ag though, have they? There were
Marla's got
some R1, right?
The ones that we've gone through here,
Yeah.
they've all been on R1s.
That's all been R1. Okay.
They've all been R1s.
So maybe 4% makes sense in ag, but then in R1 now we need to up it.
Well, I think on my acreage, I calculated I could do like a 35,000 square foot building. And currently, under the county zoning. And you know what limits me on the size of building? How much money I got. So, right? It's like, okay,
How much you wanna spend.
I'm not gonna
Yeah.
build a 37,000 square foot building because I don't need it. So,
Okay. So are we good with? Yeah. Go ahead.
One last thing on it too. We just recently had an issue to where height of building also. There were BSCs talking about dorms and that, and the height where they were going higher was totally determined on how much setback they calculated into it too. So they couldn't run the height real close to the edge of the property. I don't know if that comes into the county perspective at all, but just a little side note.
the city does that on signs too. I can go higher if I set back further.
Well, to your question, Mr. Connolly, Commissioner Connolly, we are going to start having those problems because these lots in this transfer area many of them are substandard. Many of them are less than 65,000 square feet. Some are down to 40, 35,000, so.
And that would be more like the R5, right?
Well, R2, but it's,
Okay.
yeah, I don't know. But if you want me to come to the next meeting, I can do a gradation of sizes per lot, accessory building size per lot, the size of a lot.
Well, on ag, do we want
Well, I
to
think
change
for-
it on ag, or do we want to leave it on ag, and then we can talk about it, because R1 is our next one that we would.
Well,
I don't think we need a limitation on ag.
No.
Right.
Because, if you're an agricultural use like Mr. Small, and he's got a bunch of cattle, he's got 500 head of cattle, he should be able to build whatever size building he needs to keep those cows inside when there's a storm or whatever.
Right.
I mean, just flat out, and your whatever, so I think it's, I think it's contrary to the law to put those kind of restrictions on ag property, because I don't believe that your zoning ordinances apply to ag zoning.
Yep. I think the height, accessory building heights also need to go up. Just a thought that 25 feet and 16 and a half foot sidewalls are, I mean, you can easily see some 18, 20 and more sidewalls out there for accessory buildings and in ag. And right now, we have it, in the county, it's 16 and a half feet on sidewalls, 25 foot overall height.
Medium height, medium to the middle of the gable. Keep in mind also for
Yeah.
agriculture, if it's an agricultural use building, we have no regulations on them. They can build them as big as they want, they can build them upside down. We have no regulations.
It's not an accessory building then?
It's an ag building.
Okay.
Mr. Chair.
Yes, Commissioner Streifel.
When Commissioner Small was talking about zoning on ag against farmers or for their activity, The North Dakota Century Code generally prohibits zoning ordinances from restricting or preventing the use of land for farming or ranching purposes, so we really don't have any right to.
That's,
Yeah, for farming purposes, yeah.
is there echo in here? That's
Okay.
pretty much, that's pretty much the thing. You gotta kind of leave ag alone.
If you wanna eat.
All right, so the,
I like to do
are we
that.
okay leaving the 4% in ag?
I think we need to
Let's
take
just do
percentage
away with
out.
Yeah, I don't, why, what's the purpose?
Shouldn't be any restrictions on ag because we can't.
Yeah, I don't, but say, because really, you're gonna be limited by your pocketbook anyway. You know? You don't, nobody goes out there and builds a giant building just for giggles.
So if we took the 4% lot area max just out of there?
Yeah.
Okay.
Because we're gonna raise it for the other, you know.
Mr. Chair,
Yes.
Commissioner Bittner, I mean, I agree on lots that are used for ag, yeah, let them go. But some of these lots, there are outlots in our in our jurisdictions, they're down to 5, 6 acres that are still zoned ag. So if you didn't have any limit for those, and these are usually next to residential, like Mr. Hughes here, his lot was residential, ag. So I mean, it could be problematic for these, these areas that are next to residential. I'm just throwing this out there, I don't, because not all ag lots are 40, 60 acres. Some of them are 8, 7, 6 acres.
Yeah, Commissioner Small?
Well, those wouldn't be in a subdivision though, would they?
No, no.
There's no ag zoning in a subdivision.
Unless we go to 10 acres.
The other thing, is if, they have less than 40 acres and they want to build on it, they have to plat it. It has to plat it. And when they plat it, if it's only 5 acres and it's zoned agriculture, they will have to apply for a zoning change because they wouldn't be able to plat it under ag with the way the rules are. You can't plat something that the zoning doesn't match. So they'd have to go through the platting process and change the zoning anyway if they're under 10 acres.
So I'm a little confused here because we have this ag piece, and we're saying we have all these things and coverage and heights and all this stuff, and then we're saying that, well, we can't regulate ag. I don't get it.
Farming.
Just farming.
Farming and ranching.
So if
there's still-
it's zoned ag and it's not used for farming purposes, then these rules apply. If it's used for farming purposes, these rules are out the window. Is that how I
Yeah.
understand it?
Typically, okay, so it's we're getting into the weeds on this, but they typically on a 40-acre plat, they don't have to, parcel, they don't have to plat. If they're farming, they don't need permits, except for the single-family house, they still require to get a permit for that. Their farm buildings, if they're heated and cooled, technically they need to be permitted, because they're no longer considered ag use. But that, I don't go out there and look for an unheated or a heated farm building. But the idea is that if it's 40 acres, we don't bother with their accessory buildings or their setbacks usually, but there still has to be regulations on where they put that single-family house or where they put that accessory building. So the zoning still is applicable, even if it's a 160-acre farm. It's very limited though, but when I just caution any request for unlimited accessory building on lots that are ag lots that could be down to 4 to 5 acres or 6 acres.
So do we say something about with that accessory building area is that it's anything under 10 acres has different, has the 4%, anything above 10 acres is.
I mean, or above 40. I mean, it's 40, you don't bother with any of it, but you could.
We have to have that.
I'm not sure changing the 4% on these ag lots is gonna, because you got 10 acres, you can build in almost 18,000 square foot building. So why, do we need to increase that? I don't know.
I think we need to increase it for the smaller lots,
Yeah.
the big lots like mine, it's Mox Nix, doesn't matter.
This is an ag district between 10 and 40 acres is really the first page, our definition, is between 10 and 40.
But we do have examples of less than 10 acre
Right.
ag.
So,
So then do we want to say in here accessory building coverage, when it's less than 10 acres, then you have a coverage, there is a coverage size limit
I'm sorry,
with something less than 10 acres that's zoned ag?
4%?
But if it's more than 10 acres, you're still at 4%.
Yes.
Okay.
But I can come back at the next meeting, come back with a lot size comparative to the size of a lot. Say you have 5 acres, you can have 5% or 6%. Or 8 acres like this couple tonight had a 4.42 acre lot, and they are building a 7,000 square foot accessory building. It's allowed on there.
And that's R1 though.
It was zoned R1, right?
Yep.
So, I mean, I can start at 5 acres and leave the 2, 3, 4 acres alone at 4% and go to 5%, 5 acres and increase it.
To me, I would be on board with that. I think that's
Starting at 5 acres.
right, because and if it's zoned ag, or is that
No, I was
getting
thinking
into R1 also?
these
and-
accessory buildings in R1 too,
Okay. Because in R1, it is
4%.
still 4%, yep.
So it's 4% of an acre, acre and a half.
What's that, 2,300, I think? Yeah.
That's not enough.
Not enough.
It's not enough.
Right.
So, forget about this 4% on those small lots, because you should be able to, it should be able to do a little bigger building.
Okay, I can start at 2 acres.
Yeah, 2,600, what do we think on an acre and a half? What's an acceptable size? Because the 4% is 2,600, what's an acceptable size, do we think? Like 4,000? 4,000?
6% is
2,600.
3,900, but that's, you're probably not gonna build a 3,900 square foot.
Like, you mean, you'd go smaller?
No,
Probably.
you go to 4,000.
4,000, so.
Right.
So if we say 6.5%, or no more than, then you have that 4,000.
6.5 is what we approved today.
And we approved a 6.5 just today. And that was on R1.
Yeah, if you went 6% on a half, 1.5 acres, you can get up to 4,000 square foot building.
So I think 6.5%, so I think we're
Or
jumping
6.5.
now onto R1, but I think in R1, it makes sense to go from 4% to 6.5%.
On a 65,000?
On a R1, correct.
On 65,000.
That would allow 4,000. A 4,000 square foot. Well, on an acre and a half, I guess.
Yeah.
Is that acceptable? Do we think in R1 that,
I'd be okay with 10%.
I think we should leave people alone.
I mean, we can, I mean, if, it's all, this is all up for discussion.
Yeah, I mean,
And they can't
and most
put it
people
over the top
just,
of their septic system either.
right, I mean, there's limiting factors on a lot that's that size. The property lines are your limits anyway, or the setbacks and all
The
that.
setbacks are and the septic is your limit.
So in an R1, just get rid of that and just say, obviously your setbacks are gonna be, your setbacks and your septic are gonna be.
Well, like I said, like I said earlier,
Start being a limiter.
the original reason for that was to stop people from starting businesses in their buildings. And if we're allowing some of this to a certain extent, what's the point? We've like we've got regulations that make no sense because we're doing this other stuff.
So, Mr. Chair, when I put my accessory building inside the city limits of Bismarck, I was told the reason that they had the limits was so that I could have enough grass to grow enough, to create enough oxygen for, that was what the building inspector told me. Because he wanted to start counting my sidewalks as coverage. And he wanted to limit the size of my accessory building because I had too much driveway and concrete sidewalks.
Is that for your water?
No,
Like for the,
I needed to have enough grass.
So you can mow.
I couldn't put a pool in, I couldn't have a grub pool, I couldn't, no. He wanted to make sure
that's
that
in city?
in
right?
city,
Oh, okay.
that was his reasonings.
Well, I think it had to do with the amount of hard surface in the stormwater, but that's what you call a green agenda.
Right.
Yeah. Okay, so moving into R1, we've
Back,
naturally
sorry.
gone into that. So just starting from the top of R1, it looks like in the ETA, there was a little bit of a difference with hens, foster families, or foster home adults, family childcare centers, I guess that's kind of the same thing. And then this up to 3 external employees. And then also, if you look at accessory building area also, so that, I know that was a point of concern. So do we want to bring those highlighted items into our R1 zoning? Which would be the 10 chicken hens. You could have chicken coops and 10 hens. You could have foster family homes for, is that foster family home adults?
Yes, it's for
Okay.
elderly care.
Okay, and then family childcare. And childcare centers under special use. Is that okay with everyone to pull in, or do we want to leave some of those out?
Let's just leave the number off the chicken hens.
Why are we even talking about chicken hens? I mean,
Well, we gotta put them in there so that they can have them.
On R1?
If we don't have them
But leave the
in,
number off.
leave the number off.
They've got them now in the
Yep.
ETA.
Right.
The
Yep.
chickens.
Yeah, that's what we're talking about, is that bringing the ETA, or what used to be the ETA, into the county piece. So if we bring that in, scratch the 10,
no, you know
or
what?
not.
If we're changing, yeah, but here's my problem. If we're changing all of the overriding Burley County ordinance,
Which I don't agree with.
which I don't agree with that.
Well-
We're trying to talk about, like, one of my neighbors has, probably 30 chickens.
Yeah.
Well, but
But this,
You're gonna limit-
is that R1 or is that ag?
it's R or something or another, because
Okay.
he had to do
Okay.
a plat, or somebody before him did a plat.
Yeah.
You're not gonna go out there and tell him he's gotta kill 20 chickens.
That's why we're taking the number off.
You know,
We want the number off.
it says
We don't care how many
per-
chickens. We
I
just
mean,
want you
any
to allow,
lottery, yeah, I
we
don't-
want to allow chickens.
Doesn't mean
Get
ten.
rid of the number.
No.
Right, so that would mean in R1, you can have chickens, you can have a family foster home for adults, you can have family childcare, and you could have a childcare center under a special use.
Right.
Mr. Chairman?
Yes.
I think Bismarck
Commissioner
put
Rich.
the 10 chicken, and I'm in favor of chickens.
Yeah.
Okay, I think they put the 10 limit in R1 because of these little subdivisions out there, and they didn't want somebody
Right.
with 300 chickens, right?
Right.
You know, if it's an egg, who cares? But in the R1, we should probably have a limit on the chickens.
And I mean, like we always remind people also, is that if you have an HOA, then that's going to override this. So if your HOA then says you can only have 5 or 2 or none, then that's different. But in R1,
I would agree with Commissioner Streifel. Get rid of the number.
Yeah.
But allow chickens.
just say chicken hens, scratch the 10. And then in R1, do we want to do the 6.5% accessory building coverage?
I'm with Commissioner Bittner on this
Or
one.
just
Take the percentage
take it out on R1?
Because it's going to be limiting by your setbacks and your septic and your water lines and whatever else.
So if when on accessory buildings on R1, then take out the max lot area, max coverage.
Making Mitch unhappy.
And then now we also have in here the up to 3 external employees, the 50% of primary home and 100% of accessory building sign of 3+ square feet. do we want to keep that, or do we want to pull that in? Because right now, R1 says no external employees and no more than 25% of your primary home. Oh, and this also is, so in the ETA one, it also says sales allowed, and I think, did we want to pull out sales allowed
That was
and
dis-
not bring that into the
That was
county one?
discussion on ag, yeah.
Right,
so-
in
Remove
R1,
sales.
pull sales.
Remove sales.
Sales, okay,
Yep.
so remove sales. And then, but pull the rest of it from the transfer or from the ETA into county.
Yeah, can I say a few words?
Go right ahead, yep. Is it good?
I like chickens.
Okay.
I would have 300 if I could, but if my neighbor doesn't want them, I mean, they're, for some people, they're a health issue. If you get more than 10 chickens, that's a lot, that's considered a lot of chickens.
Yeah,
Right,
Commissioner
so
Patrick.
Well, I
if
gotta tell you
if
what-
there's somebody that doesn't want them, but you're allowing unlimited, what is what's the option for that person that lives next door to them?
Commissioner Patrick, yeah.
When I was growing up, we raised from 200 to 400 chickens, and I'll be darned if I'll have a chicken next to me.
But if it's allowed by,
They're the
with
messiest,
unlimited.
they're the messiest and stinkiest
Yeah,
animals
I
you
think
can
what
ever
Mitch
find.
is saying is that if we say,
have that many.
if we take the number out, then you could have someone on an acre and a half that has 300 chickens. And,
That's my concern, Mr. Chairman. I mean, we've got it established out in the former ETA now with 10 chickens, which is quite a few
and
already.
like I say, and this
In
is
these
R1.
residential
This
lots.
is where I want, R1. yeah.
R1, you know.
I'm okay with that in R1.
That's right, that's all I'm talking about, is
Yeah,
R1.
and-
Just R1.
So keep the 10 or change that number?
Keep the 10.
They got 10 now.
Keep the 10 in R1, okay.
And the consideration here is that if somebody has 14 chickens and there's nobody complaining, they can have 14 chickens.
Yeah.
Well,
We're not gonna
that's
go out
true.
there and tell them, but if the lady next door.
I got one of those.
And I think that is all in R1,
Yep.
unless anybody wants to,
I know.
I think it looks like setbacks are,
Change the size of that sign too.
oh,
Yeah,
size of the sign, what did we,
we said 1.
Leave it at 1.
Leave it at 1
Yeah.
foot.
run, okay.
I know.
1 square foot,
none.
yeah.
Mr. Chairman?
Yes,
1 plus, yeah, 1 plus.
On a couple occasions, Mr. Robert Field mentioned that quail are a lot less messy and whatnot than chickens, and maybe we should allow quail if we're gonna allow chickens. I know
And
that's
pheasants
radical, I'm just
and
throwing this out of
ducks
the
and
sky,
geese
Bill,
and-
but
I think
Where do you
the,
stop?
I think the whole thing is sound though too. Because hens are obviously a lot quieter. This doesn't say, there's no roosters. Pheasants, you're gonna get sound. Quail, I don't know what they make for sound, but, I mean, that's why we don't allow peacocks.
I think we leave it at chickens, because
Just
that's
hens.
what's already there.
he
Okay.
thought they were easier on.
Now, if he wants quail, he sure can come in for a special use. Yeah.
So-
Okay, so that's all for R1.
Mr. Chair,
Yes.
I'd like to point your attention to lot area
For
in R1.
accessory,
No, lot area, page 10.
oh, lot area,
R1,
yes, yep.
Page 10. In the city, because of the hundreds of homes that are less than 65,000 square feet, they've allowed them to go down to 40,000 square feet if they were platted before 2004. Currently, we have 1,044 parcels, tax parcels that are located in this transfer area that are not 65,000 square feet. They're substandard lots. We're getting requests for permits on lots that are 30,000, 28,000 square feet.
Wouldn't those fall into R
No. It does
2
not.
or 5?
R2, if they're on a central sewer system. So they can get down to 20,000 on R2 but they have to be on a central sewer system,
Okay,
a community service.
so you're saying that there's lots that are requesting right now that are septic, have septic system or want septic system, or maybe
Well,
even have septic system.
We have a request to put an addition on a house that is, the square footage is, like I said, it's 36,000 square feet.
Mhm.
And so we do not have that. We have a minimum of 65,000 if platted before 2004. So we have to keep this in mind because these are going to be problematic, very problematic.
Do you have a suggestion on what we should do there? Should we take that out?
I don't know yet. I don't have a good answer for it because some of these lots are unbuildable. I mean, they have to be, I believe it's 100, minimum 100 lineal feet and 200 long and 100 wide. That's the minimum. And some of them aren't. So I don't know if we create a district for these substandards lots that would be an exception.
Wouldn't they just have to replat to a different, or rezone to a different?
We don't have that. We don't have a zone that's smaller than R1. Except R2, but then you have to be on the communities.
But the Burley County R5 district?
That's the mobile homes.
That would be just purely mobile.
Yeah.
Okay.
Mr. Chairman, the lot width and depth, that's 30,000 square feet, not 40 or 65,000. Multiply times 150 times.
The 150 by 200?
Yeah, so, I mean, those are the minimum. It doesn't matter about the max, I mean, it doesn't have to, it's not measured by, those are the minimum dimensions.
Right, right.
They can't go less than 150 feet, and they can't go less than 200 feet. They can go 400 feet wide by 200 feet. See what I'm saying? But that's for future consideration, but that's the only thing that I wanted to point out in R1, so.
Could those unique properties come under a PUD?
No, they were already platted. They were kind of just, some of them aren't even platted. They're just a parcel. Many of them, well, I would say half of them are not even platted.
Yeah, Commissioner Bittner.
Thank you, Mr. Chairman. Again, I'll ask the question. What's the 65,000 or 40,000 square foot? Why? Anybody know?
Septic system, my guess.
Yeah, that's what I was going to, I didn't ask the question because I didn't know the answer. The answer was because if you have to replace your septic system, you're likely to have another spot where you can put your septic system, which is an absolutely ludicrous reason. Because as a contractor, I can go in there and I can tear out your septic system. And a lot of these septic systems are going to the NODAC thing or the mound system, and so you're on the surface anyway, and you're relying on evaporation and the whole thing, right? So the reason that you would replace your septic system is if your soil got bound up,
Sure.
right? With a old style septic system, you were relying on the soil to soak away, basically. So your it's called perk rate, percolation rate and whatnot, established the size of your septic system. Well, nowadays, things have changed dramatically. So you're doing these surface things, and we'll go in there. We'll just remove whatever's there. If it's plugged up, people run, that's the size of these things always are including, like, you got a garbage disposal, how many bedrooms, and all that stuff. But we can go in there, and we can just remove all that, put a new one in there, done. So my point is that the size minimums were from a different era and a different time. Because as far as I'm concerned, I own a large lot, and I'm not going to move my septic system. If I have a problem with it, I'm going to address the problem, and it's going to be right there. So even though I could move it 100 different ways, I'm not going to, because I don't have to. And so my point really is that some of these things we're talking about, it's like, well, it's always been that way. Yeah, you got to ask yourself why, because those reasons went away.
Mr. Chairman?
Yeah.
Yeah, one of the other issues I'm thinking about is, affordable housing. People have to have places they can afford to buy. So if they can buy a 30,000 square foot lot way cheaper than 65,000, maybe they can actually put up a place.
And I think we could accommodate some of that, depending on how much septic. I mean, we'd have to figure that out. How much septic system would a house, a tiny house or something like that, actually need? Because that's there again. But that's all new. See, nobody was talking about tiny homes and mobile. Those all those things in the past. So times are changing, and I think it's up to us to adapt to to the realities that we're faced with today, instead of just saying, nope, it's just this way.
Mitch, I know that on that first page, R2, there is no R2.
I haven't included that, no.
Okay.
Yeah, that's.
But we will talk about that one maybe at a different
I
time,
don't think
right?
I mean, I don't really think we need to address it. It's for duplex homes or for small lots that are on a community septic system, like a large subdivision, not a singular lot. But to Commissioner Bittner's comments, the idea is that we could do these substandard smaller lots, just ask for a design system on their septic. They could go NODAC, or they could do a gravel system. I mean, it all depends on the number of bedrooms. And they'd be restricted by that, of course, but the idea is we don't have that. We can't get below the 40,000. Another thing is the state requires a minimum 40,000 for their septic systems. Doesn't mean we can't be below that. We can. I mean, but I would absolutely require that they be designed.
Yeah, but I think we should probably look at that, though.
Yeah.
I mean, it makes sense if the goal is to try to help people, like, say, an entry-level home buyer, you know, they might need something different. Because we all know that things are getting pretty expensive.
And Mitch, can you craft something like that about with I don't know, and this would be an R1, but we can go down to, I don't know what the number would be, but something with the, like you say, the engineered septic?
Yes, I mean, we're gonna be up against this because we're getting questions, I'm getting requests for permits, and I'm like, we can't even, it's a substandard lot.
And
you can't
that
build on.
minimum square footage, that'll be, I mean, I think you can probably come up with that, right?
Yeah, I could. Yeah.
Okay. Yes, Commissioner Bitter.
Thank you, Mr. So the question then further would be, how did any of these lots even get created? If the rules have been 40,000 or 65,000 or whatever, why do these smaller lots exist?
I don't know, there's over 1,000 of them, and they're in many subdivisions, the Olive Tree, Ponderosa, they're out there.
And those are RR?
Prairie View.
Those are RR?
Those are RR, they're zoned RR.
Okay,
Yeah,
gotcha.
But they're.
But non-conforming?
They were never platted, they're non-conforming,
Gotcha.
and people are living on them, they want to do it. So we're gonna have to create some kind of district, some kind of separate district for these.
Okay, I want to add.
And I would not recommend it to put it for the entire county.
No,
Yeah.
right.
Yeah,
I want to add
absolutely.
one other thing, because now there's new technology in these septic systems that address the waste and everything without even using a standard septic system. You know, there is new technology. You know, it started with the stuff up at the ranch, and Mr. Small here is actually the guy that came up with doing that up there. So, yes, there's smaller lots, and therefore it reduces the cost to the homeowners and whatever. And it ends up being a really remarkable thing, because we went, after that, I worked with the rural water so that system is being maintained similar to how it's being done in town. And some of these places, like what Mitch is talking about, maybe fall into that kind of category if they can utilize an on-site system that's different than a septic system, utilizing new technology. We should be looking at that too.
And those are individual per house, right?
Yeah, yeah. I mean, there's systems that they just recycle everything and then water the lawn. You know, I mean, the technology's there. So I think we need to be cognizant or aware of that.
Don't have to buy food.
Gotcha.
Mm-hmm.
Okay, anything else on R1 that we want to change? Yeah. Oh,
If I can add to the septic system, and a lot of it is what I learned watching, like Commissioner Bittner and other people at these meetings from prior conversations. But some of those extra things were, like you said, from the state, like the ghost platting conversation and that. What would it take, maybe working with the League of Counties, to get rid of that so that we're up to date? Is because kicking it down the road causes more challenges here. And I think previously, I'm willing to take on those conversations, but I want to go into it informed.
Yeah, I think it's real important that we just remember that just because it's always been that way doesn't mean it should be that way today. You know, we all have heard stories about that.
Okay, so on R5, Mitch, I noticed there's nothing
Yeah.
highlighted here, but there's definitely some differences.
There are, I mean, there's almost each one of them is different. And so I don't know if you consider all that part, but the big one is that you are allowed, childcare, in-home childcare up to 12 kids under the age of 12 without a special use. Again, one employee with 50% of the area of the house. Lot dimensions are the same, width, and,
I don't have any R5 in
So
my
with
packet.
the
these are
allowed,
parks.
Page 12?
yeah, page 12, with the allowed uses, I guess,
Mine
with the
is
minor
MH.
home occupations, do we want to bring those over into the? Do we want to bring those over into the county? Which would be the in-home childcare up to 12, one employee, and 50% of the floor area of the house, or 100% floor area of the accessory building.
Mr. Chair,
Yes, Commissioner Streifel, yeah.
did you just put some of the occupations, or are they limited to these 5?
They're limited to those 5.
Weird.
In county, right?
Where?
On-
In 2 places, they're limited to those 5
On
occupations.
in R5
No,
district.
but they're limited to these 5 occupations.
That's ridiculous.
Yes.
This, okay, zoning is vague. It's a whole lot like century code, but it gives you an idea. It's a representation of what a home occupation is.
It's just an example.
And these are
You just maybe
dated.
say minor home occupations,
Such, you should say such as.
or such as, yeah. Otherwise, they're limited to
Right.
5 if they were to take this
That's what
serious.
AE means, is such as.
Yeah, but it doesn't say that.
Now, the learning curve on this dressmaking, I can warn you.
A new occupation, right?
I think I'm out.
But then you're gonna have to move into a mobile home, though, Commissioner Bittner, so.
So these are for parks. These are for mobile home parks.
And then we have front setback is a little bit different. County, it's 15, ETA was 20. Any thoughts on that? Keep it the same in the keep the county piece
We don't have any mobile home parks in Burley County.
We have.
in the inherited ETA, though,
I'm
we
not sure if we have.
may
we don't.
not, or no?
No, we don't.
None? Okay.
Say the 15-foot setback in the front.
Put it right at Lacy.
Lincoln, that's in Lincoln's jurisdiction.
Yep.
So we just don't have,
But that's about, I mean, those are really about the only,
Isn't there one
Changes.
park on the north side of Highway 10 out by McDowell Dam?
no.
Okay.
There was a mobile home, but not a park.
And on Highway 10, there was a campground out not too far from the rural fire, but not mobile home park.
so
Yeah.
if on the allowed uses, do we want to bring that A, B, and C in, those minor home occupations? Those examples for the childcare, one employee and the 50%, and then just leave everything else the same that it was for county? Because there's not a lot of difference.
R5, this is mobile home parks? No.
Correct.
Do we?
Okay.
we-
And we don't have any mobile home parks?
Not yet.
Mr. Chair, it doesn't mean that we'll never get one.
Okay, well,
You
it
could have
would
an
make sense
application.
that we'd allow for childcare at least.
Oh, yeah.
Commissioner Patrick?
I think Commissioner Streifel was correct. Home occupations such as, and that means that it could be those or others. It doesn't have to. You don't have to specify.
Right.
All you gotta do is
Yeah,
say
so if we
home
put-
occupations
In two
such
spots.
as.
Perfect.
Right, when we get the full ordinance, it'll have that,
Yep.
well, those parts, sections like that will be described more fully, but.
Okay. And our next one.
So to answer your question,
Oh,
though,
yeah.
adding the home care, child care and whatnot is kind of a no-brainer.
I think
Yeah.
we should,
Right.
absolutely, yeah. The next one is the commercial district, the C district, which would, the Bismarck zoning would be CA. There's definitely some differences here.
Right.
It looks like in the ETA, it was allowing multifamily dwellings to be commercial. Why, is that,
Well, they have.
is that just high density housing?
Well,
Or,
they have a commercial building underneath, and they have the residential stuff on the second
Okay.
floor, stuff like that, but we don't have an RM. We brought that up last time, and you guys didn't.
yeah,
And there's not that many parcels out there that are considered RM. The thing is that, I don't want to get into weeds on some of this stuff, but it does allow things that we don't. And that's, I mean, that increased the use, like on page 16, by special use permit. We only allow those 4 or 5 things there. Whereas the city allows filling stations, nurseries, childcare, drive-in banks, all that stuff. So, I mean, to me, it's better to have a more defined, what you can use by special use or even allowed use,
so in the special uses, the thought would be
to move those over.
bring those over,
Yep.
okay.
Yeah.
Yep.
Commissioner Conley, you had something?
Well, to some degree, when you're talking high density in the county, part of the things that drive costs up in larger communities is the fact that if you're extending those services out. So if somebody wants to, say, build something like this and they own some of that raw land and the 50% that's still the ETA, if they're petitioning to come in and annex into the community, that's where those considerations might be more fruitful. But to have, say, the multi-dwellings in the county, that kind of gets along that slippery slope to where people don't want a lot of people close to them. So I don't know if that should be part of the conversation or not.
Because
I-
multifamily dwelling could be
I
an
wouldn't
apartment building,
recommend-
correct?
Yeah, I wouldn't recommend moving any of those, the R1s, RM, the group dwellings, none of that. Row housing is an R15, R10 and R15. We don't have those districts, so I wouldn't.
I would keep it city.
So leave
I don't want
those 3 out, okay? In the allowed uses. The density, so we, 20,000 square foot minimum for county, and it's 7,000 square foot minimum, in the ETA. Do we wanna go somewhere in between, leave it at 20, go to 7? What's the
I
thoughts?
don't understand what that means. What
Hey,
density,
Mitch, you can maybe.
what does that mean?
You can zone, if they ask to rezone in the county, if they ask to rezone commercial lot, it has to be a minimum 20,000 square feet. The city, in this same text, is
Basically just allow a lot
7,000.
smaller parcels.
Yeah, it allows a lot smaller lot parcel, and I don't recommend doing that.
To me, I think leave it at 20,
Leave
but,
it at 20, yep.
okay. All right, and then is there anything else in there? I know there was some different setbacks and things like that. I would assume just leave those at
Leave them at county.
county.
Yep.
Yeah.
Okay. The next one is the industrial. Is it? Yeah.
Yes.
Aye. Yep.
I district MA for city.
Temporary Christmas trees would be in industrial?
Yeah.
Didn't that, wait a minute, wasn't that was back in C,
That's in commercial.
in commercial.
Commercial
But
as
it's,
well.
but it's temporary Christmas tree sales.
Yeah.
To me, this just, well, I don't know, I mean, it's because that kind of, to me, falls into the sweet corn sales on the side of the road type of thing, but I don't know. That it would, I
I've
mean,
never seen a Christmas tree lot out in the county.
here it would be, because this would have to be, you would have to be commercial then to sell Christmas trees, right?
What do you mean, commercial?
Back on C.
If you go
No,
back,
you'd
it's-
have to be zoned in commercial lot, yes.
Okay,
And it's, I mean.
And then I
most
see
of
it's
them are.
under-
You see them in Menards, you see them.
yeah, okay.
Grocery store.
And that would be why it's in industrial also.
Yep.
Okay.
It's typically, there's parking there,
Okay.
there's plenty of vacant lots.
So on the allowed uses in industrial, under special uses, allowed uses special, do we want to bring these highlighted ones over? Or not?
well, if you got a drive-in theater, you might want to have a religious ceremony there.
I mean, to me, it doesn't seem, it seems like they could come over and
Yeah.
not it's not gonna hurt anything, I don't think.
Because again, it's special use, it's a permit.
Right. And then we also get into the minimum lot size. I assume we want to keep that at 20,000 and maximum lot coverage at 30%. That's what the county is now in industrial. And any other changes to like setback and building height or anything like that?
Mr. Chairman,
Yes.
I'm just wondering if if the ETA currently has a minimum 10,000 foot lot size, and we may move it to 20, what happens to the existing property?
And this is in industrial.
Yeah, right. What happens to the existing properties? Would they be out of compliance?
Do we have any industrial in the transfer area?
Yeah, I think there's like a couple of lots in there.
In industrial?
Yeah,
Okay.
let me look.
Because I know in the county, we only have the one.
I have a hard time believing there'd be anything that small in the.
Well, yeah, I would too, but I mean, it could be. that
If
something's
it
out
already,
there.
if it already was there, then it's there. I mean,
There's five lots that are zoned, 5 parcels.
So I guess back to the question, if one of those is 10,000 square feet, and we say, okay, now we're only gonna allow 20,000, it doesn't matter, because that one's already.
They're grandfathered.
That's already been platted.
Yeah.
It's done, okay. Yep. Okay,
I don't think that hurts anybody.
nope.
Nope.
But again, we're back to the allowed uses that we are in industrial. It's usually not really restricted. We don't have any of these things listed.
Yeah.
And it's very in-depth. This is one of probably the longest ones that has more different allowances than what we do.
Yeah, but as far as the, what would it be, the industrial use group, there's a bunch of them. There's a
Yes.
bunch of them that are highlighted here. Do we
Yeah.
want to bring those over? To me, I think we should. I don't see any in there that I would be concerned with. I guess
Yeah.
unless anyone has
Yeah, I would.
an issue, I would say bring them over into county, those highlighted pieces. Under industrial use group. From 19 to 20, 21, 22. Yeah, it's a really long, like you said, very in-depth, very detailed.
But you see,
Yeah.
and I'll give you just one example. We have nothing in our ordinances for propane storage or bulk storage or delivery. We don't even have it defined. So if somebody wants to open up for propane tanks, the large 50,000 gallon tanks, those are usually special use permits. And that's what some of these are.
Yeah,
But we don't have any of that in our ordinance,
in the county,
in the county.
but it is
We don't have
allowed-
cell towers. We
It
don't even have cell towers in our.
It is allowed in the ETA though,
It is.
or was.
Yeah. So it's, my recommendation is to take the highlighted ones or just transfer it into
Yep.
into the allowed uses or even the uses that require special use permits for this. So
Yes.
the idea is that these are not just put a cement plant. You have to be 500 feet. It has to be in a zone which is not prohibited. And then the other one is it has to be in an enclosed building. So there are restrictions for these.
Yep. Yeah, and I think that was what I think we were saying is you bring them over into
Bring 'em
the
over.
use group, right?
Right.
Yep.
The other thing that the county does not have is buffer zones. We have no buffer zones in either commercial or industrial.
Okay.
And that's very important because one in Minokan is next to a residential area.
And what would you suggest for buffer zones? Do you have a suggestion?
I mean, 50 feet is pretty normal. It's landscaped area. You can't see, it's supposed to designed to be landscaped or whatever, a fence or a barrier so you can't see or hear. So 50 feet, it's pretty standard.
Can you put that in, can you write that into
I
both of those
can,
use
yeah.
groups?
Yeah.
Which would be, you said commercial and industrial?
Yeah.
Right, okay.
Because we've got a commercial zone up there and next to the ranch, all the way around there, that's all commercial.
Right.
Yep.
And there's no buffer there, there's no
And
buffer there.
our second to the last one is PUD, and there's,
Mr. Chairman, I just got.
Yeah, I don't know what
Yeah,
it's.
oh, yeah, go ahead.
Okay, the only thing about the allowable stuff is, there's some of this stuff is a little on the nasty side. Manufacturing shellac, turpentine, lacquer and varnish, and then smelting of tin and copper. I mean, that's a big industrial doggone.
And it's
big-
allowed in the E ETA.
Well,
I mean-
it seems like it's a little bit over the top.
Yeah.
To me,
Maybe that should be a special use permit type of thing.
yeah, I would think that would make
Isn't
more
that-
sense.
Doesn't that go into special use, or is it not? Because it's not under allowed uses,
It's-
but it says industrial use.
Industrial
groups.
It's zoned for industrial use.
Yep.
And that's the thing, is when you say, yeah, that's,
But then-
really, who wants that? But you have to be able to allow them somewhere in your county. You can't restrict them and say it's not allowed, period.
So you're thinking, Commissioner Rich, are you thinking that we bring, Commissioner Rich, do you say that these ones that are under industrial use group, we should bring those into allowed uses special? So they would require a special use permit?
I defer to Commissioner Bittner on his
Okay.
thoughts on that. That would make, we'd have more oversight then?
Yeah, yeah, rather than just be automatically happening,
Right.
at least then you'd
Yeah.
hear it and we'd all go,
Okay.
oh,
Right.
is that something we want there? Or the commission, whoever's on the board.
Sure. So I would recommend that we, acetylene, the paint line,
Which
And sir-
page, Mr.
20.
oh, 20, yeah.
20, yep.
The acetylene and the paint, shellac, turpentine, okay, 20A and F. Maybe even I, plastics, I don't know, you might want to review that.
Well, maybe consider it along these lines. A lot of these are probably regulated because of the chemicals
No, I would
per
think they
state and
probably are.
federal. So anything that carries like regulation on multiple levels of government, those automatically default to a special use permit. Just because you have to be able to pivot as laws change. And how do you do that any other way?
These have to be contained inside a building as well.
Okay, so if we can get those somehow put into special use permit under industrial,
Yep.
So they can do it if you want. I mean, industrial use, that's what it is.
yep.
It's industrial.
And
You gotta have a place to put
I
it.
think it's interesting that there's more allowed in the ETA than
Than in
there
the
was
county.
in the county.
Right.
Well, a lot more.
Way more.
So, I don't know.
Actually, part of that, I know.
Yeah, Commissioner Patrick,
I
what's
guess I
up?
would disagree with putting those into special uses, and the reason I would, because I think as Mitch points out, those are industrial uses, and these contractors that are doing this already have licenses and those sorts of things. I don't think we need to do any of that. I think it's fine the way it is. I mean, think about this, who's gonna manufacture or compound acetylene? It's gonna be somebody that's licensed and already regulated, probably by the federal government in a lot of those cases. Like, for instance, think
So
about,
you want to put them into allowed uses then?
just leave more there, yeah.
I can live with that. They just kind of jumped out at me as being some
I don't think they need
pretty
special
heavy-duty
uses because
industrial.
They're already regulated, heavily regulated.
Well, I would, it's an educated guess, but I think some of it, the reason why it's ETA is access to more developed security systems, like the amount of police, fire, the access of trucks is.
But I think that's already there.
Mr. Chair, when you go through its rezoning of an industrial area, heavily scrutinized. We don't want that here. We want it past Minokan. We want it out there in Sterling, or away from where people live. And that's what typically takes place in an industrial. You don't have to worry about the special use permit. For a rendering plant or an asphalt batch plant, I mean, that's already allowed in there as a use. In that place that's been zoned industrial,
And then it's regulated.
right?
Yep. Okay. clear? You're
good.
Good? Okay. Our
Mr.
next
Chair?
one is, oh, yes,
Can I ask
Commissioner
a question
Streifel.
on
Yeah.
page 18? Did we
Okay.
change the building height to match the highlighted or not? Did I miss that?
Building height,
Building height and
Maximum,
accessory, yeah, the
right?
accessory building height? I mean,
50 feet to 25, or it's 25 in the
75.
county right now, 50 in the ETA. I guess what do we want?
are you looking at in,
page
No,
18?
it's
Bottom
On
of
the
page
industrial.
18, yeah.
It's 50 and 75.
under the industrial?
Mhm.
Yeah, I got principal height, 4 stories max, 50 feet.
Right,
The city is 75 feet.
75.
That's fine.
And this other one is double.
And then,
What's
so,
the-
but we would keep those county. Keep that as the county is in the green.
So leave it as is?
As of
Is
now,
that what
we would leave
decided?
as is.
Which part?
The height and,
Starting
wa-
at density and going down
Okay,
on
that
page
has
18.
not been brought up.
Great. So that would stay county by default.
Exactly.
Unless
Yeah,
we,
that's it.
unless we want to bring those highlighted ones over. To me, I don't
Well, I
think
haven't
so.
thought
but-
about it, but I can't see why we wouldn't be okay to bring it over, but I haven't spent that much time thinking about it.
So let's move the 75 feet height.
Just too tall to be in the county or?
I don't know. I guess do we want to change the height or do we not? Because there's building height principal and accessory building height. And if we bring over what was in the ETA, they would both go up. One by 25 feet and the accessory building would double in height. So Commissioner Patrick, yeah.
First question is, Mitch, why would we limit the height 25 feet?
To maximum 50 feet.
What's that?
It's maximum right now in Burley County at 50 feet.
It says 25.
Where's
We're
it?
talking about two different things.
Talking about the
There's a
access-
building
we're talking
height
about the accessory
principal
building.
and then accessory.
Yeah.
Okay, all right.
Yeah,
You're
your
going to
principal
accessory building.
is 50 feet.
Page
Yeah.
18.
Accessory is
Yeah,
25
the
feet.
accessory is not the primary structure.
Right.
Yeah, so the limit on that, I mean, usually they're smaller, whatever, they typically
So do we want to
are
keep them
I
at
mean,
50
well,
and 25 or?
No, I don't think you do, because,
Yeah.
you know, as a contractor, I can tell you right now that if we're allowing bigger buildings, that makes taller buildings because of the slope of a roof.
Right.
Okay? So there's gotta be some give and take. We can't do bigger buildings and keep a 25-foot maximum roof height.
I think it needs to go 50.
and
For the
and I can
accessory.
tell you,
For the
if
accessory.
you've got a batch plant, ready-mix batch plant, I need my 97-foot truck to put the graphics on the top of that
Yeah.
batch plant.
So
We're
change-
telling you 50 feet is max.
So change accessory to 50
Yep.
and leave principal at 50 also?
Nope, principal up 75.
Go to 75, okay. Yep, so we got the ETA for building height principal and accessory building height.
Yep.
Adopt those. Anything else in there?
The lot coverage is 2.5 times more. On page 19.
I think leave that where it's at.
The 80%?
County, leave it at 100.
Or leave it at 30?
We're at 30 and the city's at 80.
For an accessory building.
Yeah.
You're on page 8.
On page, way top of page 19,
Yes.
there's accessory building lot coverage,
Commercial area, in a commercial area.
or in industrial.
Yeah, I see it. I'm just,
So do we stay at 30 or should we, I mean, we don't have to change to 80, we could change anywhere in between. Or we could keep 30.
And again, we're talking accessory. We're not talking the main building.
That is correct. 80%, wow, that's
Why do we
that's
care?
a big coverage.
Yeah, that's what I'm wondering.
Why do we care?
Yeah.
I mean, what's the reason that we're even
Yeah.
having the conversation?
Take it out.
Yeah,
We'll have to come through this table anyway.
Yeah,
yeah, I don't.
And that is the accessory building too, not the principal.
right.
Well, we're gonna have to have stormwater permit for everything.
But we got max lot coverage, so if,
Right.
Yeah, we're not changing that.
Yep.
The 30%,
we're not changing that?
that's what,
Accessory
Commissioner
building
Pat.
area, do we want to change, do we want to just take that out?
That's why I was looking at density on page 18.
Right.
Because there we got, same kind of question, right?
Because if you change one, you gotta change
Yeah,
both somehow, yeah.
right.
The
And again,
EPA is much
good
more
question.
lenient, so my tendency is allow it.
Yeah. I just
So-
don't know why we wouldn't.
So do you keep the minimum
Right.
lot size and then change the coverage? Or do you change both? Does minimum lot size stay at 20,000? Coverage increases for density and accessory building?
This is for an industrial lots that we're talking about, right?
This is industrial.
I just don't see anybody wanting a 10,000 square foot lot size.
No.
That's just,
Pretty small.
My shop is 4,800.
Doesn't take much to get to that, yeah.
Mr. Chair, the difference is on a 10,000 lot, you can build an 8,000 square foot building.
Yeah.
On a 20,000 square foot lot, you can build a 6,000 square foot building. That's the difference.
Yeah.
And that's the counties. The 6,000, the 20,000 square foot minimum.
Yep.
I'd say keep the minimum size lot at 20,000 because I don't think anybody's doing a 10,000 square foot lot.
And then
Not
lot,
an
and then
industrial.
change
And
your
change the-
density lot
change to that
coverage?
80,
Go to 80% lot coverage?
What I would think.
Yep.
Yep,
is-
on density.
On density,
And then what
Yeah.
about accessory building?
I would remove it.
Just take that out?
Yep.
Accessory building area, remove that. Okay,
Okay, so change that to 80,
for county,
and then remove the accessory building.
right, the
Yeah, because it's not serving a
accessory
function.
building, max
Got
lot
it.
coverage,
Got it.
yeah, remove that.
Okay, so the question is, do we move these highlighted, all these highlighted items that are in the city ordinance, do we move them to our county industrial zone?
In,
Starting on page 20.
starting on page, let's see, 19, right? Or sorry,
No.
the industrial use group,
Yeah,
do we want to move, did we say we wanted to move those over to special use?
no.
No,
well,
or just
we-
Move them into normal,
Allowed use?
allowed use.
Allowed use, okay, yep. The highlighted ones, yep. Okay. And our next district is, our next piece is PUD.
Would it be easier to say what's not allowed? I mean, why are we, we're just adding so much,
That's a lot
so
of
many layers of
allowance, yeah.
fluff.
But the hard part is ordinances has to list what's allowed.
For the most part, they should have
What you're
a
saying.
fair representation, yeah.
Yep.
But it's a lot, that's.
I forgot about automobile detailing, or I forgot.
Oh, no,
I
that's
mean,
in
it's like-
I would agree with you, that one has, that's the most allowed uses I think I've ever seen.
I mean, it's great, but you can't cover everything.
No.
Right? Even with that, somebody's gonna come with something that.
Because somebody's gonna walk in and go, you know what? I want to do a lithium extraction thing or something,
So with, so just onto PUD, PUD to me, I think we just keep it the same as county. I mean, there's really,
There's virtually no
there
difference
is
on the sheets.
very little difference.
Very well.
So let's keep that one county, and then our final one, folks, our final one here, on the top 10 list is public use. And in public uses, there's a couple changes on here. It looks like with the allowed uses by right, there's 4 that would be, are allowed in the transfer area, but are not allowed in the county. So do we want to bring those 4 in? Or is it just that point that we made 2 minutes ago that no matter how many we list, there's always going to be somebody that comes with something new? I don't know.
I don't think it hurts to bring them in.
When this says municipal landfill, is that different than just a landfill? I mean,
It's not a private.
okay,
Publicly owned.
that would be owned by a town or something like
Yeah,
that.
so, I mean, we have private landfills in the county.
Yeah, Got it.
So we can change that to, well, public use is more for public land, publicly used land.
Yep.
And so it's, yeah, I don't see why, I mean, we don't have municipal landfill now. I don't know if we're ever gonna have one.
I mean, on public use, I don't see why we wouldn't just bring those 4 highlighted ones over and put them into the county piece. Is that, anybody have an issue with that? I don't. Because then our only other change is
Mr. Chair?
setbacks, yes.
So, Mitch, for the items that are currently being held at the Missouri Valley Complex, are those all listed in here? Because it is now public land.
It was rezoned.
There's rezone P.
Yeah.
So we have a racetrack, we have a motocross track, we have a rodeo, we have, I want to make sure we include them since we're creating.
Yeah.
Well, I'd have to look under public recreation group, what are listed for that.
Yeah, because public recreation group is a broad.
Yeah,
Yep.
golf courses, that's.
But you're right, yeah, none of those are.
None of those are
Here
specifically listed.
Yeah.
I'll look that up.
Okay, thank
Yeah.
you.
Whatever we have at the complex already, right?
We should at least list those.
We're out of compliance.
The only side note on the municipal landfill, the city of Bismarck does own land northeast, but we just bought a significant amount of land directly east of our current landfill.
Oh.
So I don't know what the city intends to do with that land to the northeast side, because we don't have to move infrastructure now. That's a
Yep.
huge benefit to the citizens.
So then that would be allowed.
Allowed in public.
And it looks like setbacks and principal building height are the only changes. And surprisingly, the ETA is more restrictive than the county.
Yeah.
That has not been the way it's been on the last few. So do we keep with the county piece or bring those ETA ones in for setbacks? And this is on public use, or the public use district, yep.
This works well in the ETA, but not for the rest of the county.
Yep.
I don't know if you really want to do it.
I'm inclined to keep with the county on the setbacks. The building height principle, I don't know, that's either 35 feet or what does it say, 50 feet or 75 feet, it looks like.
Then I go back to the accessory buildings again now for Buckstop Junction. We're looking at 4%. I think I'd rather get rid of that 4% again of accessory buildings.
Okay, so accessory building area, are we okay with
Scratch it.
ditching the 4% on there, out of the county piece? So we can take that
On the
out
public district.
on public
Public
district,
district,
public
yep.
district,
Public
yep.
land, yeah.
And principal building height, that's the only one we haven't committed to. Do we keep what the county has, or just go to the 75 feet that the ETA had?
75 feet?
I'm inclined to keep what the county had.
I don't know if I have an issue with what the county has.
Okay, if everybody's good with that, that is, that's all we have.
That's all we got?
That is all we have. I know, it was a quick one. But I do want to call out something that we talked about this in a couple of the public hearings of the, I don't know where we put clarity on this, but clarity when we are doing lot combinations within a subdivision already. To me, if there's ambiguous, and if it's ambiguous, then we should call something out to say that if we just want to combine 2 lots or 4 lots
That's
or whatever,
coming
if
up
it's
at
if it's
Monday,
in
this
the
month.
in that same subdivision
In a
already,
platted subdivision.
not the issue that the Hughes family is dealing with, where it's a portion of it's in and portion of it's out. I mean, I think that's okay. We'll probably have to get an answer on that, but we should have clarity on this of saying that do you have to get any signatures? Do you have to get any approval? Do you have to get any, or do you just say you plat it all together and bring it here?
Well, hopefully we can bring this back and ask the state's attorney to weigh in on this, or we have attorneys on retainer. We could ask them. I would like to bring it back to see if we can't set up a meeting with the state's attorney and see if we can't review this. But
Because I bring it up because obviously it's been brought up to us as people are asking, well, which way is it? We also have set precedent, and I don't want to, I'm no attorney, but we have combined lots.
we're not setting
With-
precedents. This
with-
is here long before
I
any of
agree.
us here.
But we've combined lots within subdivisions, how many times? A lot.
Not just us, every other jurisdiction I've talked to, it's never been brought up.
And so I don't
It's
know
just
if-
basically, it's not, there's not enough definition of enabling legislation to do either one. It's just, you say, well, I mean, that's, it has never been brought up.
Yeah, I'm just saying,
And it's
I think it needs some clarity.
In my opinion, it's kind of ridiculous, some of the things that are going on right now
Yeah.
with this subdivision.
I understand that it's a different story when it's trying to pull something actually out of a subdivision, but if it's just combining lots inside a subdivision, I mean, I don't know if we need clarity on that or not, but if we
Either
do,
one,
I would ask for it, please.
yeah, yeah.
Then we don't have, then there's no question, so. All right,
Yes, we were trying to- we'll
yeah.
have to talk about it.
All right, any other business? Anyone want to make a? Sure, if it's quick, yeah. Okay. And it's Dennis, correct?
No, the 100-year versus the 500-year. In my case, the 100-year is 1633. I talked to the State Water Commission today, and the 500-year is 1636. And I'm not sure if it's 0.5 or not, but it's about 3.5 feet
Yeah.
difference. So what's the process now? You're going to come back with the updates, and there's going to be a public hearing?
Yes, correct.
Okay, and then it'll go to the Burley County Commission?
Correct, because this is what we were doing tonight, and there's more. This isn't it. There's
Right.
gonna be more. This was our bite-sized chunk. And so we're just making some recommendations for Mitch and Marla. They can put it together into an
Okay.
ordinance and then present it to us, and then we'll have a public hearing on it, do all sorts of discussion. Then it goes to the county commission for final approval. Yeah.
Okay, because I'm one of the 1,540, and I'm sure there's 1,539 that are interested in this floodplain
Yeah.
stuff too. So, and then I guess the other thing, are these changes then for the whole county, or is this just for the ETA?
This is the whole county,
So we're in the county.
correct. And that's really what we're trying to do, is to say that we have this transfer area that used to be ETA, and we have county, and how do we make rules that now are going to govern everyone when we just, brought in this transfer area that used to have different rules. So,
Okay. And my neighbors will be happy about the chickens, so I'm glad you solved that problem.
good. I'm glad to hear we did something right. All right, can I entertain a motion to adjourn?
Move to adjourn.
Is so moved and seconded. Is there any opposition to adjournment? Hearing none, we are adjourned.
Just know that.